attorneys at the bench. Thank you, ma'am. All right, Mr. Lloyd present with his attorneys. State attorney's office is present. Mr. Lloyd is wearing long sleeve black civilian shirt, button down. He's got on civilian pants, shackled, and jail shoes. His feet are under the table and cannot be seen from anywhere in the courtroom by the jury. Bench, you ready to go? Room 3? Oh, okay, thanks. You changed it up on this one. All right, let's bring in the jury. okay, recognize presence of the jury? Defense?
We do.
All right, good morning, everyone. How are you? I hope you had a good evening. All right, the state's rested their case. The defense is now going to start their case. This is a good point in the jury where I like to remind everybody of the jury instructions. You've been at this for a while, and it's been a few days since I read the instructions to you. So I want to go over a couple of them with you. As we told you, and I'm not going to read them to you again, I'm just going to go over the highlights of things. As I told you at the beginning, you need to wait until the end of the evidence to make a decision about anything, all right? You've only heard half the evidence. Defense now going to put on their case. So you need to keep an open mind and listen carefully and closely to what the defense's case is. Evidence. Let me go over that with you all one more time. What is and is not evidence in a case like this? And this happens in every trial that we have that lasts more than a day or so. As time goes on, jurors forget what I told them, which is this. Evidence is what you hear from witnesses on the stand or from all the various and sundry exhibits that have been introduced, including videos, the guns, the casings, all of that. They've been introduced in this case. While cases go on, everyone engages in what I call casual observation and casual conversations. It's normal. Everybody does it. You'll see something or you'll hear something. Let me give you an example. Deputies are a good example. The deputies have all kinds of stuff on. They wear their gun belts. They've got badges. They've got patches on their arms, this, that, and the other. Asking them a casual question about something that's on their uniform, that's not evidence. And they answer it, not evidence, not something that you can consider. The only thing you can consider is what you heard in this courtroom.
Answers that people give you to casual questions, even if
it's a question that you're curious about, because as trials go on, sometimes jurors have told me at the end, I had a question about this and nobody answered it during the
trial. That's part of being in a trial. You still can't go get the answer somewhere else. So remember, you're confined to what you hear here in the courtroom. You've only heard part of the case. You need to keep an open mind until the end of the case. You'll get the jury instructions. I'll hand those over to you in writing and read them to you, and then you'll retire to consider your verdict. All right? So with that said, defense, you may call your first witness.
Thank you, Your Honor. The defense would call Pat McKenna.
I'm sorry, Mr. Marrero. Who did you say you're calling?
Pat McKenna.
Thank you.
And, Your Honor, before Mr. McKenna takes the stand, we would like to move into evidence what's been previously marked as Defense Exhibit I for identification. It's a photograph that was produced by State's witness, Mr. Ruth from FDLE.
Okay.
Been previously shown to the State, obviously.
I didn't hear anything of the last thing you just said. It was marked. I heard all up to the State's witness, then you turned to look at the State and said something, and I missed it.
Oh, I'm sorry, Judge. I thought this was working pretty well. The photograph that we'd like to move into evidence was previously marked as Defense Identification I.
I got that.
It was testified to by State's witness, Mr. Ruth from FDLE, formerly from FDLE.
All right, so you're moving it into evidence?
Yes, we're moving it into evidence in our case.
No objection, Your Honor.
All right, this will be received without objections as Defense Exhibit Number 1. And if we could, Mr. McKenna, if you raise your right hand, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Have a seat, sir. You may inquire.
Good morning, sir.
Good morning.
Could you please state your complete name for the record?
Patrick McKenna.
And how are you employed, sir?
I'm self-employed private investigator.
Private investigator?
Yes, sir.
Okay. Could you give the jury a little bit about your background and your history as a private investigator?
Okay. After a career as a probation officer and in the public defender's office, I went into private practice around 1981, I believe. So I've been doing mostly criminal defense as an investigator.
Okay.
Some cases assisted prosecutors, but mostly.
So by my reckoning, that's 40 years at least, right?
I think it's 75, April 75 is when I started.
Oh, 75,
so whatever
okay.
that math is.
And how did you get involved in this case?
I was court appointed. Terry Lenneman asked the court to appoint me as an investigator.
And what tasks were you given to do, specifically regarding the scene at the Walmart?
Photographs, video, some, what do you call it, drone video.
Okay. May I approach the witness, Your Honor?
You may.
Approaching the witness with what's previously marked as defense K for identification and defense L for identification.
Okay.
Sir, can you describe what I just gave you, which is defense L?
Yes, these look like the photographs that I took.
Mr. McKenna, can you pull that mic down?
I'm sorry.
A little bit? Thank you.
These appear to be the photographs that I took of the Walmart. And some shots in the parking lot above the Walmart, shots from the parking lot.
Okay.
These are all Walmart.
You personally took those photographs?
Yes.
And did the printed images fairly and accurately represent the photographs that you took?
Yes.
And when did you take those?
I want to say April of 19.
Okay. Of this year or last year? Or...
I'm sorry. I'm not sure the date. It's been
Might have
within
been a
the
couple
last
years
year.
ago.
I think it could have been a couple of years ago, yeah.
Okay. And as I said, the photographs accurately represent what you took
Yes.
at the time?
Yes.
The defense would move what's been previously marked as L for identification into evidence as the next number.
Any objections?
No, Your Honor.
This will be received without objections as as defense exhibit number 2. It's one photograph, correct?
Right over here.
Mr. Marrera, it's
sorry?
one photograph?
It's a composite, Your Honor.
How many? All right, this is a composite exhibit of 15 photographs. Are they sequentially numbered? Sequentially numbered.
Publish this to the jury.
You may.
Sure.
All right, folks, take a look at them, and when you're done, pass them to the next juror.
Where's the picture?
You can pass them as you're looking at each photograph. You don't have to wait to go through the whole packet. You can pass individually.
there it is.
Okay.
Your Honor, I'd also ask permission to publish what I just introduced as Defense 1 to the jury.
You may.
So while the jury's looking at these photographs, did you, sorry? What do you-
That's why she wanted to.
Okay. I'll give them a minute.
Everyone on the jury get to see all the photographs? Oh, there's still one down there? Okay, no worries. I'm sorry, what? Sure. Okay. All right, come on up. Everyone done looking at photographs? All right, great, thank you. You may proceed.
May I approach the witness, Your Honor?
You may.
Mr. McKenna, I'm showing you what's been previously marked as a defense K for identification. Can you describe that?
That's a disc of the videos, I believe, that we took.
Okay, that you took?
Yes.
And is there's some writing on the front of it?
Well, my initials, but it's got the name of my company, Markeith Loyd, Walmart Photos and Video.
Okay, did you produce that yourself?
Yes.
And is it a fair and accurate representation of the photographs that the jury just looked?
Yes.
In addition to some video that you took?
Yes, sir.
Okay. This time the defense would move defense K for identification into next number
Any objection?
3.
All right, this will be received without objection as defense exhibit number 3. Can you retrieve 2, Mr. Morero? Can you retrieve number 2 from the juror? And number 1? Thanks. Thanks. Thank you.
And may I publish the videos to the jury?
You may.
So before I play these, Mr. McKenna, could you just briefly describe what's in them?
My recollection is we sent a drone up in the air, excuse me, a drone up in the air above the Walmart and captured as much north, south, east, and west from an overhead viewpoint.
Was any of it done with a hand camera as well, or do you know? Do you remember?
I believe this stuff here is mostly the drone work.
Okay.
There may be some from my cell phone, I'm not sure, I'd have to look again.
Your Honor, that's all the questions I have of this witness.
All right, thank you. Cross?
Good morning, sir. Just a couple questions.
Good morning.
The photos that the jury just saw in the videos, I
Yes, sir.
believe the timestamp on the videos showed that those things were taken on August 7th, right?
Correct.
That was in 2019, right?
Yes, sir.
Okay, so that was about a little over 2.5 years after the incident that brings us here on January 9th of 17, right?
Did you say 2.5 years after?
Yes. If the incident happened January 9th of 2017, your photos were taken August 7th of 2019. It's about
Correct.
2.5 years.
Correct.
Thank you, sir. No other questions, Your Honor.
Redirect. May this witness be excused?
Yes, sir.
State.
No objection.
Thank you, Mr. McKenna. You are free
You're
to go. Call your next witness.
You can take your mask off and just step up in the box. Hold that right, step up in the box, raise your right. Face the water.
Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Remove your mask. Fine. Speak correctly.
Okay, thank you.
Your Honor, can the witness take her mask off?
She can. She's just getting set up. There you go.
Morning, ma'am.
Good morning.
Could you please state your complete name for the record and spell your last name?
Marie Cox, COX.
And how are you employed?
I own my own private consulting business.
And what do you consult in?
I consult in proper homicide processing procedures, chemical enhancement of latent fingerprints and blood detail, as well as blood stain pattern analysis.
And how long have you been doing that?
I've been a private consultant since June of 2013.
And what did you do before then?
Prior to that, I began my forensic career in January of 2000 at the Hillsborough County Medical Examiners. I was a volunteer autopsy technician where I assisted the doctors with the autopsies and preparation of evidence collected during the autopsy. In July of 2000, I was hired as a forensic science specialist, which is a fancy term for a crime scene technician, at the Pinellas County Sheriff's Office in the greater Tampa Bay area.
How long did you do that?
I was there for about 3 weeks shy of 13 years.
What sort of cases did you work with the Pinellas County Sheriff's Office?
I was responsible for responding to everything from property crimes to explosions, terrorist attacks, multiple vehicle injuries, death investigations ranging from natural suicide to homicide investigations. I was a member of their major case response team because I had some additional specializations in other forensic disciplines, which I would then employ at certain scenes if it was necessary. So I was on call and responsible for being available to respond to major cases.
Did you also do any training?
Yes, I actually, at my time at the Sheriff's Office, I developed curriculum for training new forensic science specialists. I prepared the training on death investigation, proper collection procedures, chemical enhancement procedures. I was also responsible for authoring a training for deputy recruits. They were required to spend 8 hours with us at the forensic section so that they could understand how to properly preserve evidence and how to protect a crime scene and the integrity until the response of the crime scene unit.
Okay. Now, could you tell the jury about your educational background and training that led you up to that position at the sheriff's office?
I have a Bachelor of Science from Juniata College, which I received in '94, and I had some basic coursework in chemistry, biology, physics, and their laboratory components. I received a certificate in crime scene technology from St. Petersburg. At that time, it was a junior college, and that was a certificate of 10 courses that were the fundamental for crime scene processing. So it was your photography, your basic processing, your crime scene safety, documentation, those types of courses. I obtained my graduate certificate in death investigation from the University of Florida, and I believe it was 2013. That required 4 courses in advanced DNA serology, forensic anthropology, and I was required to take forensic medicine 1 and 2. I then obtained my master's degree in forensic science with an emphasis in death investigation from National University. And the difference between that graduate master's degree is that it's not laboratory-based, it is field-based. So it was additional advanced work with documentation, processing, understanding scene-specific variables in scenes. So it was very geared towards what I actually physically do on a daily basis.
Do you have any idea how many total hours of professional education you've had?
I have over 450 professional hours of education. That is typically done through places such as the Institute of Police Technology and Management. I've had training through the FDLE, Florida Department of Law Enforcement. I've had training through agencies that have brought in private consultants who are educated in disciplines more so than I am, such as reconstruction or some type of digital evidence for those types of forensic disciplines that I'm continuing my education on.
Can you describe for the jury what your responsibilities are when you show up at a crime scene and how you evaluate the crime scene, how you detail the crime scene?
I do still actively respond to crime scenes. As a private consultant, I am still called out by local agencies to respond. And when I'm there in the capacity of a crime scene technician, it's my responsibility to identify, document, to locate, to process, to prepare the evidence to be packaged and for chain of custody. So I am responsible for that. I am proficient in the documentation processes of not only photography, but as well as sketching.
All right. Have you done any teaching on these subjects?
Yes, I began teaching at traditional brick and mortar. I began teaching at St. Petersburg Junior College in 2000, where I instructed on introduction to crime scene technology, advanced crime scene technology, and introduction to forensics. And I also teach at the Institute of Police Technology and Management. Recently began teaching there. And I also do a lot of guest speaking for local, for associations like the Florida Homicide Investigative Association. I've done a coursework for the University of South Florida's cold case conventions. So I not only teach professionally in a traditional brick and mortar, but I also guest speak and teach at local agencies where sometimes I'll physically go to the agency and do processing techniques for them so that they may be able to increase their knowledge of processing for their forensic evidence that they collect.
Your Honor, at this time, the defense would move the court to, for permission to allow Ms. Cox to render opinions in the field of forensic crime scene investigation.
Do you wish to what, dear Mr. Buxman?
Can we approach, Your Honor?
You can.
All right, Ms. Cox, could you tell the,
Hold on.
I'm sorry?
Court reporter's still setting up.
Oh, I'm sorry.
Take your mask off, Mr. Maroon. Yeah. Thanks.
Okay. Ms. Cox, could you tell the jury how you got involved in this case?
I was contacted by Mr. Linneman in September of 2018.
All right, and what was your task?
He had asked me to do a case file review in reference to the crime scene processing that had occurred, referenced this incident, to take a look at the materials that were relevant to the documentation, collection, processing, and eventual chain of custody of the evidence that was collected in this case.
And what sort of files did you review?
May I refer to my report?
Oh, yes, please.
I reviewed several files that were specific to the processing techniques, which would include the crime scene photographs, autopsy photographs, additional evidence photographs. I looked at, there was Leica, which is a very high-tech scanning program. I took a look at those images. I viewed the video and the rooftop still shots from the Walmart. I also reviewed official law enforcement reports, including the reports of crime scene technicians, as well as some of the first responding law enforcement. I reviewed other official law enforcement programs, such as response, what they call the CAD report, crime scene logs, and any type of official laboratory reports as well.
Were you aware of all the evidence that was documented and collected from the scene of the homicide?
Yes.
And do you know, was all the evidence collected from that location?
There was, I am under the impression that all the evidence was collected, not all of it was documented.
So if it wasn't documented, then how did you find out about it?
That is part of the reason why I do read the official law enforcement reports, to include the crime scene technician reports, as that is a form of documentation process that as crime scene technicians we are taught. And in the subsequent report, I became aware of a possible projectile or a possible projectile fragment that had been collected but was never documented.
Did you obtain information about where that fragment was recovered?
Yes, I then continued to review case files, and of which I came across information from a detective, the individual who had identified the item, and that individual had indicated a approximate location of which the fragment projectile had been located.
Now, in photographs that the jury's seen earlier, there appear long yellow crime scene tapes. And did you see those in the photographs?
I did.
And did you become aware of the approximate sort of boundaries of where that tape was on the scene? In other words, what was included inside of the yellow tape and what was not?
Yes, I did.
Do you know where the bullet fragment was found, the projectile?
Upon reading the case file and that information from the detective, it was identified as being located outside of the perimeter. And having worked several crime scenes, I understood what the perimeter indicated. That's the exterior perimeter of the crime scene tape. And this individual also indicated that it had been located down near the south entrance, which was several yards away from the north entrance where the incident had occurred.
Now, there were no photographs actually documenting precisely where the projectile was located. Is that correct?
I have not seen any, not been presented with any.
So other than that general description that you just gave to the jury, did you have any other information about where the projectile was located?
No.
All right. Did you know that the detective had contacted a crime scene investigator regarding the finding of that projectile?
I did read that in the case file review, yes.
Do you know if any crime scene investigator responded to the detective's call?
They did not.
Is that appropriate documentation?
I did not feel like that was appropriate. Not only was it located on the same day, it was confirmed that a shooting incident had occurred there that day, and it is not uncommon in an outdoor scene when there's multiple rounds discharged from a weapon that there may be some evidence that's outside of the perimeter. That is not uncommon based on the general variables of that scene, the scene-specific variables. So it's not uncommon for that to occur. So in response to that, it's not uncommon to be called back to a scene to continue the documentation that you had already previously begun for that investigation. That did not occur in this particular instance.
Now, one of the crime scene techs did respond back to the scene later, is that correct?
2 times later.
Okay, but in neither one of those events was the projectile's location documented?
There were several additional photographs taken, but the report only indicated that this individual had responded back to the location. It did not provide any information on the directive of the reason or what they had intended to document.
All right. After you reviewed all the documentation and data in this case, did you ever visit the crime scene?
I did.
And what did you do? What did you do there, and why did you do it?
If I have the opportunity, there's, in addition to responding to active crime scenes, there are times when I am not afforded the opportunity as an agency or an investigative service may not realize that they need some extra expertise. So it's not uncommon for me to get called into a case after a crime scene has been released, and I've been called in several years later to several other types of scenes that are considered to be cold cases. So if I have the opportunity to respond to the original location, I will do that. And I do that just to see if, typically just to get a spatial feel for the area, because although documentation is done at different angles, you really sometimes can't get a feel for how large or how small an environment is. The other thing is, this being an outdoor scene and it being a commercial business, there's a lot of other scene-specific variables, such as pillars, that would impede somebody from driving up into the pedestrian area. So there's all those types of variables that may not necessarily every single inch of them be documented in a photograph. So I go there in order to do that. I also, in this particular situation, went there because I was honestly confused as to how that projectile or possible projectile fragment had ended up by the south doors. So knowing that it was an outdoor scene and that there were multiple rounds discharged, I just wanted to walk around the Walmart to see, is there any indication, can I find anything that might allow me to determine possibly how this projectile or possible projectile fragment ended up near the south doors of this particular location.
And were you able to find anything?
Yes, I identified what I believe to be a possible defect, sometimes called strike marks.
And did you document that strike mark?
I did.
And when you came back to your office, did you attempt to locate any photographs taken by law enforcement to see if you could locate that strike mark on their photographs?
Yes, so the process that when I do a case file review, it's a fluid process. So when I obtain information, and I like to just kind of describe it as a cone, and the base of the cone is very wide, and you have a lot of information, and you're not quite sure where the evidence is going, and so then you do a little bit more reading and a more case file review, so you can kind of go up the cone a little bit to get a better understanding of that particular incident. So once I had identified what I perceived to be the defect, I went back and I thought, okay, well, let me see if I can identify this in any of the photographs that were taken the 3 times that the agency responded. And I did locate a photograph of which the strike mark or possible strike mark was visible in one of the photographs.
Did you do anything to that photograph to enhance the appearance of the strike mark so it was more easily visible?
I did actually. There's non-invasive techniques because there were no what we consider to be mid-range or close-up photographs of the strike mark in any of the photographs that I observed. So what I had to do was take every single photograph and I had to identify if that window frame of which I identified the strike mark was visible in that photograph. If the window frame was visible in that photograph, then I would very slowly zoom into it. And depending on the resolution, sometimes what we call pixelation would make the photograph too blurry to see anything. So I had to systematically go through all these different photographs until I finally found one where I was able to zoom in just enough that I felt comfortable saying that the location of it, the relative appearance of it, and the overall photograph was consistent with what I had physically seen at the scene. And that is all done, and then I crop it. And then sometimes I'll use different lighting. All of this is non-invasive. I'm not altering the actual original photograph. I keep the original photograph, make a copy so that these non-invasive techniques are not done on the original copy, so that the integrity of that original photograph is still maintained.
So what was it about this defect that you observed and documented that drew your attention?
I have worked hundreds and hundreds of shooting incidents, and I am familiar with strike marks in different types of surfaces. So when
you say strike marks, you mean precisely what?
From a possible projectile or projectile fragment.
From a weapon?
From a discharge of a weapon.
Okay.
And so when I went to the Walmart, and I looked from all the way from the north end all the way to the south end, looking up and down on the pillars, on the windows, on the ground, looking everywhere. And that was the only defect that I observed, and it was within the alcove in close proximity to the north entrance doors. So that was why the importance of that particular strike mark or that defect.
Okay. Now, did you find any sketches or additional Leica scans that addressed that mark, that defect? Was there anything in the state's evidence, in the documentation that you reviewed, besides that photograph, that documented that strike mark?
No, I did not receive any additional Leica scans where that strike mark was intentionally diagrammed. No.
Okay. Did you took photographs of your own? Is that correct?
Yes.
And did you do anything besides taking photographs of the scene?
After I took the photographs and returned to my office and did some more case file review, I then read more in depth the statement of the detective who identified the possible projectile, and I remembered that he had made a reference to the fact that the projectile might have been close to an unmarked vehicle. He wasn't sure, so I'm taking all this information in, and then I thought that I would view the rooftop stills and the video in much more detail to see at that point if I could possibly see if there was any continuity between the incident and the location of this new defect and the location of the projectile.
Okay, did you draw up any sketches or anything of that kind?
Yes, I actually responded back to the Walmart a second time, and I intentionally went early in the morning because my intention was to do a video from a perspective of the rooftop stills that was unclear to me. Some of the original video from the Walmart and the rooftop stills was obscured by signage on some of the pillars, and I did not find adequate photographs that had been taken by the agency that would allow me to determine if there was even something what would be considered line of sight based on the two areas of which the video was not clear.
Okay, may I approach the witness, Your Honor?
You may.
Ma'am, I'm showing you what's been previously marked as defense M for identification. Do you recognize that?
Yes, this is a CD of my videos as well as some sketches and the photograph that I identified.
There's some initials on the front, and there's some evidence tape on the back. Did you put those there?
Yes,
Did you create this exhibit?
I did.
Okay. Your Honor, at this time, the defense will move and for identification and evidence.
No objection, Your Honor.
All right, this will be received without objection as Defense Exhibit Number 4.
Nancy Curtis, if you could open it for me. This is in exactly the same condition as it was when you sealed it up?
Yes.
Could you open it up for me? Proffer the photographs and videos to the jury.
You may.
Okay. The first image that's being shown is very small. Do you recognize that image?
Yes.
And what is it?
That is the cropped version of the photograph taken the second time the agency responded to the Walmart. That is the window frame, and there is what appears to be a shadow area. If you're looking at the photograph, it's immediately to the right of the pillar, and it is above what would be considered the sill or the shelf of the window. It's on the actual lower frame of the window. That is what I identified as the defect.
Now, you said cropped, so this is a small portion of a larger photograph that was taken by, probably by CSI Livengood, is that correct?
That is correct.
And you cropped it down just to the important part, or the part that you deemed to be important, is that correct?
Correct.
But you didn't otherwise alter the photograph or change any aspect of it, is that correct?
I did not.
Is this the original photograph?
That is not the original photograph. That is, I have actually cropped, but not as closely. So this would be considered a mid-range view of the potential defect. And I've also not only cropped it from the original photograph, but I've lightened it so that you have more of a contrast and the actual shadowed area becomes more visible. And it's, as you can see, once again, to the right of the pillar, and it's on the actual window frame, not the windowsill.
How about this photograph?
That is the original photograph.
Okay. So we kind of showed them in reverse order. This is the photograph originally. You were able to spot on this photograph that defect on that window frame?
Yes.
Did you spot it on the photograph before you saw it in person, or did you see it in person first and then try to locate it in the photograph?
I saw it in person first.
The record reflect on board shown state defense N for identification and applications.
You may.
Ma'am, could you describe what I just handed to you?
are my photographs of the defect.
And do those photographs accurately and fairly represent the scene as you saw it and observed and photographed it the day that you took it?
Yes.
And when was that?
I responded and took these photographs on October 2nd of 2019.
Do they still appear to be in the same condition, or the defect appear to be in the same condition as it did in the state's photographs that were done by the crime scene investigator who responded to the scene on the day of the event?
The location of it, these are my close-up photographs, and previous photographs to these close-ups. This defect is in the same location that I found when I went back and reviewed this particular photograph.
At this time, the defense would move defense N into evidence as the next number, and then Proffer to jury.
No objection, Your Honor.
All right, this will be received without objection as defense exhibit number 5. It's a composite exhibit consisting of how many photographs? Is it 3 photographs? All right, composite exhibit, 3 photographs sequentially numbered. Okay. And you may publish. Same procedure as before, folks.
Now, Ms. Cox, what was it about that defect that made you photograph it so closely and made you be interested in it?
The initial thing that drew my interest was it was the only defect that I found to that metal framing on any of the windows at the Walmart. So when I first identified the defect, I wanted to make sure that this was not a manufacturing issue with this particular type of framing. So I was drawn to it because of that there was no other defects that I could attribute to a manufacturing issue. Then what drew my attention was the size of the defect and its location and proximity to the location where the incident had occurred. The other thing that was of interest to me was the fact that it did appear to be what is considered to be a possible strike mark, which means it had characteristics that were consistent in appearance with what's called a ricochet, which basically is consistent with an item coming into contact with a surface and for lack of a better term, bouncing off, as opposed to entering that particular item. So then an accumulation with the fact that there was, in fact, a possible projectile or fragment located on the same day of the incident that was over by the south entrance, all of that accumulated together is what, and the fact that there had been weapons discharged and the fact that a shooting incident was not in dispute, that was what really brought my attention to that particular defect.
Is there anything in particular about those images that look like a bullet, like it was struck by a projectile, a bullet?
It's consistent in appearance with other scenes that I've worked where metal-based items have been struck by projectiles.
And how high up off the ground was the bottom of the window frame?
I actually did put a measuring device in there to memorialize that in my overall photographs. I was a little bit higher than 4 feet. And the interesting thing also was that it was in the inset alcove. And once again, it was not on the window sill that protruded out. It was actually on the frame so that the window itself is inset. And there's a little window sill that comes out. It was in that particular area.
Did you observe the shopping carts that were at Walmart?
I did. As a matter of fact, when I took my original photographs, there was a shopping cart almost right next to the window upon my arrival.
And the mark is where in relationship to a shopping cart?
It's above. It's a few inches
So it couldn't have
above.
been caused by a shopping cart.
Somebody would have had to pick up the shopping cart and swing it into that area because the windowsill protruded out and the actual defect was higher than your traditional shopping cart.
And there's a roof over that window as well, so it's like sort of protected from the elements to some extent?
Yes, there's a small awning that protrudes out.
Okay, so we talked earlier about some sketches that you made, and I think you said that the reason that you made these sketches was to try to see if there was a line of sight?
Yes.
And could you just go into a little bit more detail with the jury about what that is?
A line of sight in basic generic terms is whether or not if a normal individual was in a location and looking in a certain direction and the end target was visible and unobstructed. So that would be what a line of sight is. So that's what I was attempting to determine was there were 2 frames of the video that I was not sure because they were obstructed by some signs, so I did my own documentation to determine whether it was or whether it wasn't available.
So is it fair to say that you were trying to figure out if either one of the shooters could have had a clear shot to that window?
Yes.
Okay. Now, we have up on the screen a sketch that says sketch parking lot. Did you create this sketch?
I did.
And could you describe it to the jury?
That is a very small sketch version of the actual Walmart, which is a very large Walmart. And as you can see, it's not to scale, so these are not, the sizes of the items are not meant to be mathematically correct. It is for demonstrative purposes only. So this is a process of which I used in conjunction with all of my case file review, as well as visiting the Walmart myself and reading the different statements and reports of individuals. And I did what is called a layering sketch. So what I did was I identified, based on the photographs and the Leica scans, where the individual vehicles are related to this particular scene. Now, there were other vehicles at that location, but the reason that I only selected the law enforcement vehicles is because that was a reference that was made by the detective in the information in the case file, that he thought that it was possibly near an unmarked cruiser, but couldn't be sure. So what I did was I identified the unmarked cruisers, which have little arrows that say unmarked police cruiser, and then the other cruisers just say police cruiser, and that would have been a marked unit. So I identified the location of all those vehicles. The next thing I did was, because I had no documentation, either in report form or photographs of exactly where that fragment was located, I had to consider an area as opposed to a point. So what I had to do is determine if that possible strike mark was in fact caused by a projectile, possibly this projectile, what would be my possible ricochet area. So that is what this particular area is. My dimensions, you'll see I have one long purple line that goes from possible strike mark towards the south edge of the building. That is going to be considered one of the outer perimeters of the possible ricochet area. That's based on the structure itself. The line that goes straight down the middle, that's a purple line that goes straight down the middle from the possible strike mark, goes down along a police cruiser line, and that perimeter, or that ricochet perimeter, was determined based on, once again, that it was identified as being outside of the perimeter, and that crime scene tape in the photographs and the Leica scans, the furthest south perimeter was over that vehicle. So that's how the possible ricochet area was determined. And based on that, you can see that all of those police cruisers towards the south are in proximity of the possible ricochet area.
So, okay, so the purple line that goes straight up and down in the image, that is where the crime scene tape was, which was the outer perimeter, as you said, of the actual crime scene?
That line is not the actual crime scene tape. The tape actually went across the vehicle and then a little bit over to the left. But for the purposes of the ricochet area, I made it a straight line.
Okay, so, and then the purple line that comes off of the wall, that's not, you didn't put that line in there to say that that is absolutely the trajectory of this bullet fragment, is that correct?
No, this is a ricochet area, not an absolute trajectory.
So when the purple line goes all the way to one of the unmarked patrol vehicles, you testified earlier, and I don't want to put words in your mouth, but that could have been the vehicle where the projectile was found, but you don't know.
Correct.
It could have been one of the other unmarked police cruisers, but you don't know that either, right?
Correct.
Because it wasn't documented.
Correct.
And so essentially, is that purple line just to show that there's a clear shot, for lack of a better word, from where the fragment might have been found and to that, where you found the strike mark?
Yes, I felt that if in fact that was a projectile that had caused that strike mark, that where the projectile was identified through the case file review would have fallen within the plausible ricochet area that I identified on my sketch.
In other words, like if that fragment had been found all the way past the home and living part of the store on the other side of that wall, it couldn't possibly have bounced off of that wall. Is that correct?
Correct.
All right. Okay, now this next image sketch is titled Sketch Parking Lot with Possible Line of Sight and Ricochet Area. So it looks a lot like the last one that we looked at, but you added some things.
Correct. This is the second layer, my second layer sketch, where I have now, based on when I responded back to the Walmart to do my video, I established that there was a line of sight available from the original areas at the beginning of the incident that were not clear on the Walmart video or the Walmart still shots. So because I didn't have any other additional documentation, I created my own based on all of those scene-specific dynamics. And once again, this is not to scale, and it is approximate, but it does document the location of Lieutenant Clayton and of Markeith Loyd based on those still shots. And that is how I came to determine those approximate locations of those two individuals, and both were within the line of sight of the possible strike mark.
And that's what the blue line that's off, I guess it would be like around 8 o'clock on a clock.
Correct.
That's what that line indicates? That
Correct.
there's a clear view from where Lieutenant Clayton was all the way to the strike mark.
Yes.
Okay, and this sketch is titled Front View Sketch, No Possible Line of Sight. Could you describe that?
This is just a different perspective as opposed to looking down on the sketch. This is more of a front view as if you were standing facing the Walmart. And once again, it's not to scale, it is approximate. And this is the first layer sketch where I've just identified the approximate locations of the individuals. And then I took a snapshot of my actual photograph of the strike mark, and I placed it in there with possible strike mark to identify the location of it as if you were looking forward.
Now, when you say or title it No Possible Line of Sight, you mean you just didn't put in a line of sight in this image, in this sketch?
Correct. This is the first layer sketch.
And this image appears to be similar, except you've added something.
Correct. I've added the possible line of sight.
And again, this is simply to show the jury that from where you know Lieutenant Clayton was at one point, because the video obviously obscures, there's plenty of parts on the video that obscures either or both of them. Is that correct?
Yes, so I viewed all of it, all of the still shots and video.
But it's essentially, you're showing here that from where you have, and I'm assuming that the female sort of looking dummy that shows up on this image, that's where Lieutenant Clayton was?
Correct.
And then the male one is Markeith Loyd?
Correct.
And you're showing that from where she was standing there, she had a clear shot all the way to the possible strike mark?
There was an unobstructed line of sight.
Now, you also made a PowerPoint video
Yes.
or a presentation, shall I say?
Yes.
Okay, can you tell the jury what we're looking at?
That is the first slide of this presentation, and that is the rooftop still shot that I was looking at in order to determine the approximate location of Lieutenant Clayton and Markeith Loyd at the beginning of the incident. And this slide was chosen because there were no photographs taken by the law enforcement that were taken from that perspective, which is one of the reasons I chose that slide and did additional work on my own.
Now, you know, we keep talking about the line of sight, but you don't actually know whether or not Lieutenant Clayton fired, just from looking at this picture, whether or not she fired at that window. Is that correct?
I do not, no.
There's no images actually that you reviewed that show her discharging her weapon in such a way that it could have hit that window?
No.
But it's possible?
Based on everything that I've reviewed and additional information I've obtained, I cannot eliminate that the line of sight was available.
And the next frame?
That was the second frame, of which I was unable to find any documentation done the day of the incident or after the incident that provided me whether or not the line of sight was visible from that perspective. As the still shots and video continues, the movement of Lieutenant Clayton becomes much more, is not as obstructed by these signs, and those perspectives were already documented by the law enforcement agency. So these were the particular slides of which I felt that I needed to do additional work because they had not been documented.
And you used these images to help you construct the sketches that we just saw?
Correct.
Go to the next slide.
That is just the photograph that was taken the day of the Walmart of the incident. You can see the law enforcement personnel is still present. And I just wanted to document that as you go further in this presentation, that the structure of the Walmart itself had not changed. That's the reason that an original photograph was placed in that presentation.
All right. This appears to be the same photograph, but you've added things to the next frame.
Correct. I've identified the individual who took the photograph, the fact that it was a scene photograph, the fact that it was, in fact, I gave it its designated number that was assigned by the law enforcement agency, and I do indicate that that is a cropped, that is not the original photograph, that is a cropped version of the original photograph.
What about the white characters that show up in the photograph?
Those were placed in there by myself.
And what did you use to establish their placement?
The first two slides, that is the approximate location in the first two slides.
And you wrote in yellow letters here, possible strike mark with a yellow oval. You put that on there?
Correct, to identify the location of it on the window frame.
Okay, and this image, which is DSC 005?
That was taken the second time the third time the response was made by the law enforcement agency. And I included that in there because it was one of the few that was kind of close to the line of sight that I was trying to find, but it just didn't give the exact reference points that I was looking for. But I did want to put that in there to demonstrate that.
All right, this image looks like identical to the last one, except you've added something?
Yes, I have added the demonstrative mannequins representing Lieutenant Clayton as well as Markeith Loyd and the possible strike mark.
And this next frame?
I took 4 series of videos, and that is the first video that I took from the approximate location of Lieutenant Clayton in the 2 frames. It's an approximate location of the 2 just to demonstrate that the line of sight was visible from both.
And on the bottom of the photograph or the video frame, it says that it was taken on August 19th, 2020 at 6:30 in the morning?
Yes.
Why'd you take it at 6:30 in the morning?
I was aware that the original incident had occurred early in the morning, so I wanted to make sure that I was respectful of the possible changes in lighting and the fact that it was dusk. I believe the sun had just risen the day of the incident, but I went there prior to the Walmart opening in order to be respectful of their business and to not impede their business activity, but to be respectful of the fact that the incident had occurred in the morning.
Are you walking or are you using a Zoom?
No, use a Zoom.
And what are you zooming in on?
The line of sight and ultimately the location of the projectile, possible projectile strike.
And the next video is taken the same day, around the same time?
Correct.
And what do you document there?
At this point, I've moved to the approximate location of Markeith Loyd, as documented in the still shots, and I am once again documenting that the line of sight continues and is unobstructed.
And I guess that doesn't need any description. You put on the image, a snapshot of video, defect visible.
Correct.
And this one?
That is, at this point, I am now standing in close proximity in front of the possible strike mark, and I am taking the video outward away from the strike mark towards the road to provide a different perspective.
The next photograph, same thing?
That's a snapshot of the video.
Okay. Same photograph, now you've added something?
Correct. That is demonstrative to just provide a different perspective, a different demonstrative perspective.
All right. And that's the end of your presentation on this?
Correct. Yes.
Now, since the last time that you were deposed, we've taken in evidence in this case. We've had testimony. And you and I have spoken, is that correct?
That is correct.
Did I share with you any testimony from this week's evidence?
You did.
And what testimony was that?
You provided me testimony from the ballistics expert that testified in reference to the projectile and its possible inclusion or exclusion of a weapon.
And do you have an opinion about that now, based on what you already knew and based on what you've heard from the testimony of the expert, Mr. Ruth, who testified?
Object, Your Honor. Opinion about what?
Sustained. Yeah.
Has anything that you've heard since you were deposed changed your opinion about what that defect was and the line of sight?
Some of the information that was provided through this testimony was specifically relevant to the actual condition of the projectile, as well as what weapon it could be excluded from and what weapon could not be excluded. With that additional information, that has brought my case file review even further up on the cone. So I would indicate that the discharge of Lieutenant Clayton's weapon toward the Walmart cannot be excluded.
The condition of the bullet fragment and the testimony that came in about the condition of the bullet fragment, was that consistent with your, your indication of the defect itself off the window? In other words, if Mr. Ruth testified that that bullet fragment was severely damaged as though it had bounced off of something, was that consistent with the defect that you found on the window frame?
Yes, that is one of the primary pieces of the testimony that I considered.
And if Mr. Ruth's testimony was also that the projectile could have been fired from a weapon similar to Lieutenant Clayton's, and that the characteristics of the projectile were consistent with the ammunition that was loaded in her gun, would that also add to your feeling that this actually was a bullet ricochet?
That does provide more probative value to the fact that I cannot exclude that this is a projectile strike mark.
Okay. May I have a moment, Your Honor?
Yes.
I have no further questions, Your Honor.
Cross.
Good morning, Ms. Cox.
Good morning.
Can you leave that up? Oh, yeah, thank you. Now, referring to the defect that you've been talking about on the windowsill at Walmart, you cannot say that it is a strike mark from a projectile, correct?
I can't say it definitively is. I also cannot exclude it.
And that is why you continually use on your diagrams and your testimony as a possible strike mark, correct?
Correct.
And if it is a strike mark, you cannot say when it was placed there, except for that the defect, according to the photographs, was present on January 15th of 2017 when the crime scene investigator took that photo.
Correct.
Okay. Except for saying that something struck that windowsill, you can't say how that defect got there.
I cannot definitively give an absolute no.
Okay. Or who caused it to be put there.
I cannot.
And even if it did come from this incident, you can't say in which sequence of gunshots that defect was placed there, correct?
I cannot, no.
You talked about the documentation in the case file regarding the projectile found by Detective Overfield. Would you agree with me that based on the documentation in the case file, you were able to determine who collected it, the projectile, right?
Correct, yes.
Where the projectile went after Detective Overfield collected it?
Yes, that was documented.
As well as a general location of where that projectile was found?
That was all documented via report writing.
Okay.
Yes.
How did the failure to document the specific location with, say, a photograph of this projectile affect your analysis in any way?
How would it, the failure to do that?
Yes.
If the actual location of the defect, or excuse me, the projectile had been identified, so would have the condition of the actual projectile, which I didn't have any indications of. So I may have been able to come to some of the conclusions I've come to today at a much earlier point in time, as well as be able to be a little more probative in the possible ricochet area. So that's the...
Have you looked at the actual projectile?
No.
Okay. Did you make any requests to do so and were denied, or just you did not do that?
I didn't do that because it had already been tested and handled by multiple other experts, so I was going to rely then on their reports.
Okay. And you're not saying that because it was handled by other experts, it would have altered the condition of the projectile substantially, are you?
Oh, no.
Okay. And you're not saying that if you would have a photograph showing exactly where this projectile was found, you would have been able to determine definitively it was fired from Lieutenant Clayton's weapon, are you?
No.
Okay. Or who fired first?
No.
And if you would have had better documentation of the location of the projectile, you still would not have been able to determine in what sequence of gunshots this projectile was fired, correct?
Correct.
During your years of crime scene work, would you agree that in many occasions projectiles become fragmented?
Yes.
They can become fragmented by striking a surface, right?
Correct.
They can become fragmented even by entering a body.
Correct.
So the fact that if this projectile did strike this windowsill, that in and of itself does not mean that it would have, there are other reasons why a projectile would be fragmented simply by striking a hard surface, correct? And like you said, if it enters a body, it could become fragmented.
Correct.
So you're not saying because the projectile was fragmented, it must have hit this hard surface, are you?
Not definitively, it just can't be excluded.
And I believe you testified at the end of your direct examination that the projectile that we've been talking about, found by Detective Overfield, you agree that scientific analysis could not say it was fired from Lieutenant Clayton's gun, correct?
My understanding from the notes that I took that it could not be excluded or completely identified, so it was inconclusive.
Okay. And for that projectile to make that defect in the windowsill and end up where it ended up when it was found by Detective Overfield, there are a variety of concrete pillars and barriers between that defect and where it was found, correct?
There is.
Now, you created the exhibits that we looked at earlier, placing Lieutenant Clayton and Markeith Loyd in positions so as to demonstrate the possibility of the scenario you have described, correct?
I wanted to demonstrate the possibility of the line of sight based on the other evidence that was in the case file.
Okay. And obviously, all of those exhibits assume that the defect in the windowsill was caused by a projectile, right?
That is the understanding, that if that is in fact a projectile strike mark, that the line of sight was available.
And all of those exhibits assume that the projectile found in the parking lot was what caused that defect, correct?
It includes the possibility that that defect could have been from that, or excuse me, that projectile could have been from that strike mark, or
And
have caused that strike mark.
I'm sorry. You said that you did review the surveillance video from Walmart, right?
I did.
And you touched on this, I believe, in your direct examination, but would you agree that the video footage that you reviewed and the images you reviewed do not show Lieutenant Clayton firing her firearm in that direction of that defect?
Are you asking if I have something definitive like a muzzle blast? Or?
Yes, ma'am.
No, I don't.
Okay, and the video doesn't show her arm extended pointing a firearm at that area either, correct?
No, it doesn't.
Okay. When you added the figures in the diagram, the stick figures, I guess, you manually placed those on the diagrams yourself, correct?
Correct. They're for demonstrative processes.
And you manually placed them in the locations that you estimated them to be based on the still shots that you saw from the video, correct?
That's correct.
Now, am I correct? You did not import the video into some kind of a mapping program to put those figures in the exact locations they would be in the video?
No.
Okay. Didn't use any kind of geometry or trigonometry to analyze angles or anything, correct?
No.
The same with the line of sight sketches of the store and the parking lot that we showed the jury earlier. The locations of everything are estimates based on your view of the images in the video.
And my response to the Walmart on 2 occasions, yes, sir, and the location of the strike mark.
But all of those, the figures themselves of the representing the people were placed, they're estimates by you, right?
Yes, correct. Those are approximate locations.
The ricochet area that we've been talking about, the sketches that we showed earlier, it says possible ricochet area.
Yes.
Okay, and again, you use the word possible because you don't know if that is an actual ricochet area, correct?
Correct.
And the reason you created that ricochet area, the one barrier is basically the Walmart wall, right?
Correct.
We know it couldn't have gone beyond the wall because you didn't see any other strike marks.
Correct.
And the other ricochet area is basically the crime scene tape.
Well, it's an extension of the crime scene tape because the tape went over the vehicle and then was attached to another pillar. So the straight line is just an extension.
And if that crime scene tape was placed originally in a different location, that would have become your other barrier for that possible ricochet area, right?
I felt comfortable using that location because in the photographs that were documented by the agency, that's where the crime scene tape was. According to the information I obtained from the detective, he identified that location of the projectile after the team had left. So I had no reason to believe that he had found that prior to the tape being moved to the location it was documented in, because he did specifically say it was after she had left. So that's why I used that as the perimeter.
And when you refer to the detective's statement about where it was found, I'm assuming you did not call Detective Overfield and show him the diagram and say, did you find the projectile in this area, correct?
No.
Okay. For the sake of argument, let's assume that Lieutenant Clayton based on your theory, did fire her firearm, the projectile struck that defect in the windowsill and ricocheted off into the area where Detective Overfield found it. Would you agree that none of your analysis indicates who fired the first shot?
That's correct.
Okay, or when the defendant first had his hand on his gun?
I have no way of knowing that information.
Or at what point he drew his firearm?
I have no information on that.
Or how long after Lieutenant Clayton ordered him to stop, he drew his firearm?
I have no information on that.
Your analysis does not show what the defendant did after Lieutenant Clayton ordered him to stop.
No.
Correct? Or why he pursued Lieutenant Clayton after she fell to the ground?
No.
Can I have one moment, Your Honor? Thank you, ma'am. No further questions.
Redirect.
Briefly, Your Honor. Ms. Cox, if you'd have been a crime scene investigator and had responded to the scene of where the projectile was found, how would you have documented it?
If I had responded to the scene?
Yes.
I would have requested that it be marked and protected prior to my arrival. I would have responded back and continued with the same processing techniques that I had employed on the original documentation. If I was responsible for doing photography that day, I would have photographed it with and without scale. And if I was responsible for the Leica scanning, I would have Leica scanned it. If I was responsible for the video, I would have videoed it.
Okay, when you say you would have Leica scanned it, what exactly does that entail, and what would we be able to see if you had done that? Sorry.
You can put markers to reference items of evidence for your Leica scans, and then this is just based on my experience in working around it. That data can be then downloaded, and then sketches and things that I did can also be done.
Okay. Now, is it a fair description to say that the work that you were doing on this case, the photographs that you were taking, the video that you were taking, that you were doing that to see if you could exclude the possibility of Lieutenant Clayton having shot her weapon and having that projectile hit that window frame and bounce off?
My intention was to go there to see if it could or could not be included.
And ultimately your opinion, you're not here testifying that you know for a fact that Lieutenant Clayton fired first, and you know for a fact that that projectile came from her gun, correct?
Correct.
But you cannot exclude it.
Based on the additional information on my case file review, no, I cannot.
In other words, all the evidence in this case cannot exclude that as having been a realistic possibility.
For me, the review that I did and the responsibilities that I had, and based on the new information, I cannot exclude it.
Thank you. That's all I have with this witness.
May this witness be excused?
Yes, Your Honor.
No, Your Honor. All right, thank you, ma'am. You are free to go. Folks, why don't we take a break? We've been at this for a bit, so 10 minutes. officers present. Ready to call your next witness?
All right, let's go. All right, let's get the jury back in. Thanks.
If we could hold off one moment, Your Honor, I think the next witness, I do have an objection to some of the evidence that they're going to be introducing.
Okay, who's the next witness?
Who's the next witness? She's asked you a question. Who's the next witness?
Oh, it's Livengood.
Okay. If I could have one moment, Your Honor.
Sure.
Ted. Yeah.
How long are you all expecting this witness to take? Yeah. How long are you all expecting this witness to take?
I have to go to publishing about 17 photographs,
Uh-huh.
and primarily, yeah, there's a few other things, but maybe 20 minutes.
Okay. State, 20 minutes, sound about right? 20, 30 minutes?
I was speaking with Mr. Buxman. Totally missed what you were asking. I'm sorry, Judge.
How long is this witness supposed to take? They're saying 20 minutes. Do you have a lot of cross?
I don't anticipate a lot of cross, Judge.
Okay. All right, this will be the last witness before lunch, so we ready to go?
Yeah, ready.
All right, let's get the jury back in here. Thank you. State recognized, presence of the jury.
We do, Your Honor.
Defense.
Yes, Judge.
All right, call your next witness.
We call crime scene investigator Livengood.
Mr. Lineman, mask.
Oh.
Yeah. Thanks. All right,
We call crime scene investigator Livengood.
we'll need to re-swear her, please.
Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do. Have a seat, ma'am. You may inquire.
Would you tell me your name, ma'am,
Karen Livengood.
and how you employed?
I'm actually retired.
And you were the main crime scene investigator in this particular investigation involving Lieutenant Clayton?
Yes.
Okay. Yesterday, there was some discussion amongst myself and the state and you in regards to some photographs that were documented in your report and photographs that were actually taken. I want to talk about that, ma'am, okay?
Okay.
You prepared a report in this particular case of all the work that you did.
Yes.
Your Honor. Now to the question, to the purpose of the witness.
I'll let him continue a little bit.
Yes, Your Honor.
Is that correct?
Yes.
Okay. Did you include in that report information about photographs that you had taken on January 15th, 2017?
Yes.
Okay. And do you recall what the number of photographs that you said you had taken or documented in your report that you had taken?
Yeah, I think I put on there 33 and I miscounted.
Okay. So let's talk about that. We had a discussion yesterday that you explained to me why you had put...
Objection, first of all, to referencing any conversations and also calling a witness to impeach.
All right. Let me see the attorneys at the bench, please. You may proceed.
Ma'am, I'm going to show you what's been marked as composite for identification, defense identification as P, and I'm handing you some photos. I'm going to ask you to look through them and let me know what you've done with them.
Had you have an opportunity to look at those photos, ma'am?
Yes.
What are those photos?
These are photographs that I took.
And when did you take them?
They're not all from the same date.
Okay. Are there photos included from January 15th, 2015?
Yes.
Or 2017? And how many photos did you take that day?
At the Walmart?
Yes, ma'am.
I don't recall exactly how many unless I could look at the actual proof sheet itself, but there's 18 here.
Okay. And you said not all of them are from the 15th.
That's correct.
Okay. Do those fairly and accurately represent inclusively photographs that you had either taken on the 9th or the 15th?
Yes.
Okay, I move that into evidence, Judge.
Any objections?
I just need to see them.
Okay.
No objection, Your Honor.
How many photographs are there?
There are
22? All right, so this will be admitted without objection as defense. Composite exhibit number 6 consisting of 22 photographs.
Ma'am, are you able to identify the photographs that you took on the 15th versus the photographs that you took on the 9th?
I can tell the difference, yes.
Okay, so I want to go through these so we can publish them. I'm showing you which is P3. What is that and when was it taken?
This is going to be the right side of the pharmacy. It's going to be the southeast corner, I think it is. And I don't know exactly when I took these, if it's part of the same batch. This was done on the 15th.
Okay. Can I see that?
Sorry.
I'm going to publish, Judge, as she goes through them.
Yes, sir.
Showing you what's P4. P5, P6, P7, P11, P12, P15, And this is P22, which appears to be the 9th.
Yes.
So you recognize all those?
Yes.
They were taken by you?
Yes.
And, okay, let me publish them. I didn't publish all of them, but there are others in evidence that appear to be photographs which include a memorial to Lieutenant Clayton, but they're available to the jury. Okay, I have a question for you. Why did you go back on the 15th to take photographs?
Just took some additional photographs.
Were you directed to do that?
Yes.
By who?
Detective Cadiz.
And did he tell you why he wanted you to go back and take photographs?
Objection, calls for hearsay.
Sustained.
Without telling us why, did he give you information that he wanted?
Yes.
Now, you had testified previously that you had taken a photograph of a strike mark. Is that correct?
Yes.
Okay. And when we went through the photographs, I asked you if there was a photograph of a strike mark, and you offered me an explanation about the strike mark.
Okay.
What was the strike mark photographed?
Why was it photographed?
What was the strike mark photographed of? What were you photographing?
Just an indentation that was on the walkway or parking lot.
Okay. Was it on the ground?
Yes.
Okay, so it was
on the
not
ground.
actually on the ground.
It was on the ground.
Okay. So you never took a photograph of a strike mark on the wall?
No.
Ma'am, I'm going to ask you a question I've already asked you, because it was pointed out to me I violated my own rule by asking questions while the jury was doing something else. Is that okay?
Okay.
Did you take a photograph of the strike mark?
Yes.
And what photograph did you take of a strike mark? What was it?
Well, I can't tell you exactly what it was, but it was just a mark that was on the ground.
It was a mark on the concrete ground.
That's correct.
Okay, you never took a strike mark of a wall?
No.
All right, thank you. I have no further questions.
Cross.
Good morning, ma'am.
Good morning.
Mask.
I was going to be brief, but yes, ma'am. You missed the potential strike mark on the wall, right?
Yes, I didn't know of any on the wall.
That's all. Thank you, Judge.
Redirect. May this witness be excused. Mr. Lanneman?
Yes.
All right. State.
Assuredly, yes.
Ms. Livengood, you are free to go.
Thank you.
All right. I've been told that your lunch is up on the way, so we're going to go ahead and take the lunch break now. We'll be back at 1:30, resuming testimony at 1:30 in this case. All right, I'm reminding you all that we will be in court tomorrow from 9 to 1. And have a good lunch break. I'll see you after there. And I'm working on the requested letter to an employer, all right? Anything from state before we break for lunch?
No, Your Honor.
Defense? No. All right, have a good lunch, everyone. I'll see everybody. We're going to start at 1:30.
Yes, Your Honor. Thank you.
All right, we're back on the record on State versus Lloyd. He's present with his attorneys. The state attorney's office is present. So let's bring the jury back in. Yeah. Jury in. State recognized, presence of the jury?
Yes, Your Honor.
Defense?
Yes.
All right, welcome back. I hope you guys enjoyed your lunch. All right. Defense, you may call your next witness.
Principal Dan Doskey, please.
So, what room are you in? Are you in room 1?
Okay.
Okay.
Bigger the box, you take the mask off. It doesn't
Okay.
close the mic.
Thank you.
Step up in the box. Face the clerk and raise your right hand, please.
Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Have a seat, sir. You may inquire, Ms. Tonya.
Would you state your name, sir?
It's Dan Doskey.
And how are you employed, Mr. Doskey?
I'm the Vice President for Video Services at Legal Graphic Works.
And what kind of work do you do there?
So we're a litigation support company. We do any kind of work to help attorneys present their cases.
Okay, and can you give us some information about your background?
Sure. So I've worked in video editing and with cameras since 1993. I attended the University of Florida. The major at that time was called telecommunications, which is basically broadcasting. Worked in television news until 2007, and then started doing litigation support work. So at the beginning, it was literally cutting tape with a razor blade and a grease pencil. And of course, now we do everything by computers, but that's the length of time. I think we're at 28 years now.
Okay. And there came a time where I hired you and asked you to do some work.
That's correct.
Okay. Can you tell the jury generally what kind of work I asked you to do?
So it was at the simplest form, editing some video, which was surveillance footage. Also reviewing that footage to ensure that it was intact, that it was complete, that there weren't any issues with it. And then on the little bit more complicated side, magnification and changing contrast and brightness settings to see if there was any way to see more detail in any of those images.
Now, when you're talking about looking at the actual video, I imagine like speed and things like that, can you tell the jury a little bit about that and what this video is made of and how it is created and how is it stored and how is it viewed?
Yes, so most of the video that we're going to be talking about is premises surveillance footage. So it was recorded at a store, and those systems have, and there's a specific reason for the way they do it, but they generally will record at lower frame rates than the video that you would see, say, on television. So the frame rate for this video is 5 frames per second, and what a frame is video is really just a collection of still images. So each time the camera captures a still image and puts it in line, that's a frame. So video that you watch on the news or on your favorite TV show or at a sporting event, usually going to be at least 30 frames per second, may go all the way up to 120 frames or faster when they're doing like slow motion replays of like a football play or something like that. This is about 5 frames per second. So in terms of quality of the video and what are the action you can see, this is much less than you would see like on television or broadcast quality. But the reason that they do that in surveillance systems is because they need to save 24 hours a day, maybe on 12 different cameras, and they need to hang on to that for possibly a month or 6 months or a year. So the storage of all that footage, if you saved everything at a really high quality, would be, it would cost a lot of money, and it would physically take up a lot of space to have all of those computers and hard drives and everything to save all of that. So most surveillance systems that you see are gonna have video recorded at a lower frame rate and also at lower quality so that they can keep more of it for a longer period of time.
When you're talking about a lower frame rate and lower quality, what, if anything, do we miss when that's the situation?
So, like I was talking about before, where you might see a slow motion replay at a sporting event at 120 frames per second, the reason you want that high frame rate is so that you can see exactly, and it stays crystal clear when something's moving, if the receiver's foot's out of bounds, or if the runner's foot or hand has touched a base or whatever it is, if it was baseball or football. When you have a lower frame like this is 5 frames per second, it's capturing 5 images per second. So the faster things are moving, the more you're going to miss. So you could move your hand back and forth a few times in a second, but if you're only capturing 5 frames, you're going to miss some of that action from point A to point B and then back again. So the faster things are going, the more important frame rate becomes.
Okay. And so when I asked you to do some things in this particular case, did you generate some files in regards to that?
Yes.
Okay. And in preparation for today, did you load those files onto a flash drive?
Yes.
Okay. Do you have the flash drive on you?
I believe Ms. O'Shea.
Okay. I need to move into evidence first. Please.
State, have you seen this?
They've seen it.
Okay. All right, are you moving this into evidence?
Yeah, Judge.
And what is it?
Is it fairly and accurately depict work that you did in this case that we've talked about today?
Yes, it does.
Okay.
All right, this will be received without objection as Defense Exhibit number 7, This is a flash drive containing a variety of material.
Thank you. Yeah, plug it in. Do you have to turn this on, Judge? Okay, there we
No,
go.
it's on.
Okay. So can you turn it
Been
this
on the
way?
whole time, yeah. There you go.
Okay. Where are we? Can you exit that out first? Right. But exit out first. Okay, so where are the videos? Give it to me, look at the piece of paper. Thank you. Okay, let's talk about what you were provided initially from me. Can you tell the jurors what you were provided initially from me in this particular case?
So you provided me selected video files from Walmart. Those files were in a Windows media format. That's what I initially received.
Okay. And as you moved along doing work, did you shorten those files or condense those files in various things that can be seen by the jury?
Yes, we did. You know, that's editing. So editing's a non-destructive process. It doesn't destroy the original, still exactly like it is. But once we're done editing, we have something new that, you know, looks different, it's shorter, it's cut up differently, it might be slower, etc.
Okay.
Yes, we did edit.
And how many cameras, well, let me step back for a second. When you were provided the initial camera footage from Walmart, were there areas both inside and outside the store?
Yes.
Okay. So some of the areas you see from cameras depicting the grocery area, the cash register area, maybe the dock?
That's correct.
Okay. And we kind of focus on how many different cameras when you were working with me on preparing for trial?
Primarily 3.
Okay. I'm going to show you the first one. Which is labeled Rooftop Cam GN to N2. Is that this camera? Is that this video?
Yes.
Okay. And so in this particular case, at the very beginning of this video, we see to the left a thing that can be toggled, I guess, by whoever's operating this so they can choose a time to view the video. Is that right?
Right, yeah, it's a slide bar, scrub bar that you can move along to jump to different points in the video.
Okay. And so what we found was relevant to the shooting was a time period that was around 7:15.
It's 7:17 in about 45 seconds.
Okay. So what I'm hearing and what I'm doing is fast forwarding the time.
Yeah, you're jumping ahead.
So if someone wanted to look at the time before or the time after that's on this video, they can do that themselves.
That's correct.
Okay.
If you move the mouse up off of that line, it will, that'll go away.
And this is the incident of the shooting that you worked on, correct?
Correct. Now, what we're looking at here is the original footage provided from Walmart to Orlando Police.
Now, you can stop this, move it back and forth, correct?
Yes.
Now, how do you stop this to free?
The blue button in the middle.
Okay, got you.
Yeah, that one.
Okay, so what we saw was someone run by here and now is running in a different direction?
Yes.
And then turns back around and has a firearm in his hand?
I'll say yes.
Okay. So pretty much if you have a laptop and this disk with this information, you can go through and track the time and the things that the folks are doing on here, correct?
Yes. Now, on these particular files, there's a video codec, which is like a language that certain files need to communicate with a computer to play the video back. That's located within this folder. That has to be installed on the computer. Once that's installed, then you can play it back. But so everything you need to watch it is on the drive, but to watch these particular files, which are the original videos from Walmart, you do have to install that onto your local machine in order for it to play back properly.
Okay, and you'll provide us that specific information so we can provide it to the technical folks here?
Yes.
Okay, thank you. The next...
And that's another reason that we edit the footage sometimes. It's just because it's not easy to play back on any computer when it's in a proprietary format like comes from the store.
Okay. And the next video you received that you worked on, you said was the Southwest, grocery to Southwest?
Yes.
And then that's a different camera.
Correct.
And the same way you can move it forward. Now this appears to be darker. Do you know why that is?
It's 6:45 in the morning.
Okay.
The other camera had the same time of day, but just different lighting conditions, depending on how the light hits the lens, et cetera. You're gonna see it look a little bit different.
And again, you can move up to the time a little bit before or after, whatever you want to do.
That's correct.
Up to you. And the same with the other camera. You can view whatever portion you want, correct?
That's correct.
And the last camera?
Is the SD Grocery DJ ENT VEST, which is the entrance vestibule. It's not that one.
It's not this one?
No.
Okay.
It's 2 down from that one, from where you are.
This one?
Yes, sir.
And what is this?
So that's a camera from inside the store that's pointed out the doors of the, I assume it's the grocery entrance.
Okay. Yes. Hold on. Can I have a second, Judge?
Yes.
Hold on. Okay, I want to take you back a little bit on this video. What time does that say?
6:44 and 55 seconds a.m.
Now let's go back to what we were looking at before. Now, Mr. Doskey, from this view, we're looking outside?
Well, both really. So the camera's inside, pointed toward the outside, yes.
Okay. And do you know which direction this is if you were to go right outside the door?
On the compass?
Yeah.
I do not.
Okay. Okay. And one more portion here. Okay. And those are the 3 videos that you worked off of? Hold on. I want to go back over something real quick.
Sure. Do you want me to answer that last question?
Yes.
Primarily, yes. Those were the 3 videos that we worked with.
Okay. Okay, what time is that?
It's 6:44 and 55, 56, 57,
Okay.
so on.
What time is that?
7 a.m. and 25 seconds.
Okay. What time is this?
7:17 and 45 seconds.
Okay. All right. So next I want to go to the work that you did. That's in video exports?
Yes, sir.
Okay, let's talk about the drone footage that you collected.
Okay.
Tell the jury about how you collected that.
So there were 2 different dates that we went to the Walmart property. One was March of 2020, and one was about a week ago, October 20th, 2021. We went to the property, launched the drone. In March, we flew across the front of the building from, I think we started right to left and then back left to right. In October, we flew up over the Walmart building out to a wooded area, and I believe that's on the north side of the building, but from the building across the parking lot over to that wooded area. Landed, and that was it. It was
Okay. And
probably less than 5 minutes both times.
I'm showing you what's indicated as 3101 West Princeton drone footage on 3/4/2020.
Yes, sir.
I don't know why it's doing that. Do you know why? Because it's not doing that on my computer.
I'm hoping it's just a loose cable, a loose cable on the back.
Okay. Okay.
There you go.
It's good to have an IT guy on the stand. Nope, not it. Let's get out of this and try it again. All right. And the second one is entitled Walmart Drone Overview 10/2021.
Yes.
Okay. And then I'm going to go to the second one down, which is SD Grocery DJ.
Okay.
Do you know what that is off the top of your head?
So that's going to be the camera that's inside the vestibule looking outside, and those numbers on the front side of that file name indicate the time. So that's from 7/16/52 through 7/17/45.
And do you do anything other than convert the, just splice it? Do you do anything, enhancement or anything like that?
No, there's nothing.
Okay.
Nothing's adjusted here. It's just the video as it was edited down. So I apologize. This one is the external camera. That same doorway, just looking outside and to the right.
Okay, the next one.
The next one down is the interior from 7/17/38 to, I lost the title, but I think it's to 7/18 and 0 seconds.
And the next one down?
That is the rooftop GM to N2, 7/17/47 to 7/18/59.
And the next one, sir?
It should be the same thing. The _1 is usually what happens when you just duplicate a file, so that may have just been a mistake.
Okay.
That it got copied in there twice.
Apparently the size is very close.
Yeah.
Okay. And so the next one with Southwest?
Yeah, so that's the other rooftop camera that we talked about earlier from the same time period.
The next one, sir?
That is back to the GM to N2 rooftop camera, and that should be an 8-second clip from 7/17/52 to 7/18/0.
Okay. The next one?
The next file is an audio file. It was provided to me by you with, you told me it was a radio call and asked to first 1 minute and 5 seconds of that radio call.
Okay.
And, to leave the rest off. So this is 1 minute and 5 seconds of a radio call.
Do I press Windows Media?
That'll work for you, yep.
There's been 1033 traffic on emergency north, revolver 20 out of the Walmart, 101 West Princeton Street, reference attempted contact, possible signal 5 suspect, 1033 on emergency north.
Which line route here? We broke over here. Wow, 26 officer.
Yeah.
Sarge, where are you exactly?
I guess we're looking for Markeith. He's walking out the door right now. I guess he's involved in the shooting with Clayton Senior. I'm at the first entrance.
Do you have eyes on him? Do you know a vehicle?
Bravo 20, 10-4.
Okay, how do I get that? A moment. Okay, the next one is entitled Lloyd Compilation. What is that?
So that is a video edited together from the 3 cameras that we spoke about before. You'll see it runs through one time in real time, but you also see the videos magnified in places. We also adjusted the brightness and the contrast, no different than how you do on your TV at home, just to see if there was any more detail that could be gotten from the image. So it'll run through those scenes a couple of times. The second time through a little slower.
Are you highlighting that?
Yes. That's it for that one.
Okay. ML exits, entry and exit grocery?
Yeah, so that's another, a different camera that we haven't talked about before. That's a little bit further back from the entry and exit doors. And you'll see Mr. Lloyd exit Walmart.
Overhead, external?
Okay, so there's two cameras that are, one's on the outside of the doors and one's on the inside of the doors, but they're both pointed almost straight down to the ground from overhead.
Did you also prepare some stills?
Yes. If you click on the top left where it says USB drive D, that'll take you back out, yeah.
And this one here. Are those the stills you prepared?
There were 11 in total. That's 8 of them. The other 3 are just in a different folder.
Okay, we'll start with number 1. What is this?
That's from the, yeah, there you go. That's from the interior vestibule camera at 7:17:41 a.m. That is magnified.
Okay. Number 2?
That's 7:17:58 from the rooftop GM to N2 camera.
Okay. Number 3?
It's the same timestamp, but it's a different frame from that same camera.
So this is when you're talking about 5 frames per second?
Correct. So you'd see, when things are moving, you would see 5 different images for each second of the clock that ticks by.
Okay. Number 4?
Same image as before, but magnified.
Okay.
So same image as WM03.
And 5?
That's 7:18:0 from that same rooftop GM to N2 camera.
And this?
This is the rooftop grocery to southwest camera. And that's a magnified image from that camera. It's not the full frame.
And 7?
7:18:02 from the rooftop grocery to southwest camera. Again, it's magnified.
And this one?
7:18:03 from the rooftop grocery to southwest camera. Again, that's also magnified.
And the other stills are?
October 2021.
Okay, we'll start with 9. What is this?
That's from the entry-exit camera that's on the outside of the building, 7/17/39, and that is, that's the full frame, so that's the whole camera view.
And 10?
So that's 7/17/58 from the rooftop GM to N2 camera, and it's got a highlight circle over Lieutenant Clayton.
There came a time before trial that I asked you to prepare some demonstratives.
Yes.
I'm showing you what's been previously marked as defendant's identification B. Do you recognize this?
Yes.
What is it?
It's a print of the image that we're looking at on the screen right now.
Yeah, thank you. Is it fair and accurately represent the work that you did in the image that you produced?
Yes.
Move into evidence, Judge.
Any objection?
No objection, Your Honor.
I recently received without objection stating that it comes for defense exhibit number 8.
All right. And so you did the red circle?
Yes.
Okay. I'm just going to publish it for a moment. Did there come a time that you did also a similar one, which is defense identification E? You recognize that?
Yes, sir.
Did you do this one?
Yes.
Does it fairly and accurately represent the digital image that you created?
Yes.
And move that into evidence?
No objection.
I recently received without objection defense exhibit number 9.
Publish that to jury. Did there come a time where I asked you to blow up a photograph that was taken by our investigator, Mr. McKenna?
Yes.
Okay. I'm showing you what's been marked as defendant's A for identification. Do you recognize that?
Yes, I do.
Okay. Is it a fair and accurate reproduction of the photograph that you were provided?
Yes, it is.
Okay. And it's fair to say that you don't know when this photo was taken?
Correct. I do not know when that photo was taken.
Yes. Yes, I'm sorry.
Okay. This will be received without objection.
You saw these, right?
Number 10.
Thank you. There came an occasion where I asked you to reproduce an item. This is defendant's identification D that the state had provided me. Do you recognize it?
Yes, I do.
And did you reproduce the item?
Yes.
So it became this blow up?
Yes.
I'd move this into evidence, Judge. Same one.
No objection to Testify.
All right, this will be received as defense exhibit number 11. Partners, is this the same one that came with the state?
Yes.
Okay.
I'm showing you what's been marked as defendant's identification F. Do you recognize that?
Yes.
What is it, sir?
An image that was emailed to me by you.
Okay. And does it fairly and accurately represent the recreation that you made?
Yes.
I move that into evidence.
Objection?
No, Your Honor.
Okay, this will be received by objection as defense exhibit number 12.
Please publish. I'm showing you what's been marked as defendant's G for identification. Do you recognize that?
Yes.
What is it?
It's an image that you emailed to me.
In the same condition that it was when you created this?
Yes, so it's a request to turn it into a printed board.
Okay. I move this into evidence, Judge.
Any objection?
No, Your Honor.
This will be received without objection as defense exhibit number 13.
Oh, sorry. Oh, actually, this is not it. I think that oh, yeah, I'm sorry. I'm confused. Thank you. I'm showing you what's been marked as defendant's identification. Do you recognize that?
Yes, I do.
What is it?
It's an image that you emailed to me with the request that we turn it into a board.
Okay. In the same condition that the photograph appeared is the condition that this does?
Yes, sir.
Blow up? Okay. Move H into evidence.
Objection?
No, Your Honor.
This will be received without objection as defense exhibit 14.
This is it. Publish it to the jury.
Yes, sir.
This is H. Oh, I'm sorry.
Hold on, let's make sure we got them all marked.
Okay.
Go ahead.
Thank you. Publish it to the jury, Judge.
Yes, sir.
I'm showing you what's been marked as defendant's identification C. Do you recognize that, sir?
Yes.
Is that something you created?
Yes, it is.
Was it created off the work that you did prior to on this particular still?
Yes, sir.
Just enlarged?
Correct.
I'm moving to evidence.
Any objection? This will be received as defense exhibit 15 without objection.
Publish it to the jury, Judge.
Yes, sir.
Ted, you can take that. I'm done with that. I'm showing you the last still, which is number 11. Do you recognize that?
I do.
What is it?
It is a still we created from the video with a red ellipse or circle on top of Lieutenant Clayton.
Okay. What we discussed was all the work you did in terms of for this particular trial?
Yes.
Okay. I have nothing further, Judge.
Thank you. Thanks for the excuse. Mr. Lyman?
Yes.
All right, thank you, sir. You're free to go.
Thank you, Your Honor. Thank you.
All right, so this seems like a good time to take a break. This may be a slightly longer break. It's an hour and we'll take care of it. Make yourself some coffee and relax. I'll get back as soon as I can. Thank you.
That's a flash drive. Yes. Okay.
Do you have some proffers to do this? Do you have some witnesses to proffer?
Yes.
What will we do first?
We'll do Detective Savelli.
All right. We can get Detective Savelli in, please.
Get with your mask, sit close to the mic, speak directly.
Yes, sir.
Step up, raise your right hand.
Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do. Thank you.
You may inquire, Mr. Lawrence.
Good afternoon, Detective.
Good afternoon.
Would you tell me your name?
Sure, Brian Savelli, Brian
And how are you-
Savelli.
I'm sorry. How are you employed?
Orange County Sheriff's Office.
Okay. How long have you been doing that?
Since June of 2007.
Okay. Did there come a time when you had a conversation with Mr. Lloyd's niece?
Yes, sir.
Was this after, subsequent to the Dixon shooting?
Yes.
Okay. And can you tell me what the conversation was?
I met with her Christmas Eve of 2016 with a couple other deputies, and we were just asking for cooperation to put the manhunt to an end.
Okay. And did she tell you something about what Markeith had said?
The way she answered some questions led me to believe she had spoke to him.
Okay. And what did she say that led you to believe that?
She was inquiring about if there was a firearm left on scene.
Okay. I don't plan to introduce that, Judge, so the court knows the gun issue I'm not going to introduce. Did she say that Markeith wanted to surrender?
I believe there was some talk about that, yes.
Okay. Did she say that he wanted the truth to come out first?
There was something along the lines about stuff that was being portrayed.
Okay. But was it your understanding that that he I'll strike that, Judge. And did he feel someone was lying based on what she told you?
I don't know how he felt. I just remember the talk with her about some discrepancies.
Okay. Okay. That's it, Judge.
Okay.
Detective Savelli, do you recall the niece ever expressly telling you exactly what Mr. Lloyd said? In other words, did she ever say, Markeith Loyd told me, and then relay anything to you?
No.
So this was all her interpretation of something, but you don't know from who it came?
That is correct.
That's all, Judge.
Yes. Did she ever tell you that she had a conversation with Markeith and he told her that the press was distorting on what was happening, and you said you had no control over that.
I remember there being talk about what the press released, and I remember saying that, yes, I had no control over that, but I don't remember her specifically saying, Markeith told me this. I just remember it was a general conversation about what was in the press, and I believe I did make that comment that I could not control what was released or what the press was reporting.
Did she ever tell you that he wanted to surrender, but he wanted the truth to come out?
I remember some conversation about that she wanted the truth to come out, and that, but I don't remember if she exactly said he'll turn himself in if this is said.
Well, Judge, I have a motion in addition to what I'm requesting, and that is the truth.
Okay, are we done asking Detective Savelli questions?
No, we're not, because I'm going to be asking the court to
Well,
designate.
if we're going to talk about his testimony, he needs to
Gotcha.
step off the bench.
Okay.
Or not off the bench, off the witness stand. If you
Yes, ma'am.
step out, Detective, thank you. Okay, let's start with the testimony he's given me right now.
Okay.
All right, are you still asking to call him as a witness?
Well, I'm asking to call him as an adverse witness, Judge, because.
Based on what?
Based on the fact that he lied just now.
And the proof of that is what?
Deposition, page 60, beginning with line 3. Actually, let me read the entire, line 5. Question, and that Markeith wanted to surrender, but he wanted the truth to come out first. Answer, as you're saying this, yes, I do recall that.
State response.
I'm sorry, Your Honor, I'm trying to read the transcript to see the context for what was just read to the court. If I could just have a moment.
Sure.
Yes, that is what the transcript says. So what is Your Honor asking for my response to?
He's saying that he wants to call him as an adverse witness and put all this in and then impeach him with the prior deposition.
Well, my response, Your Honor, is that the first step would that this testimony would be relevant. And I don't think we've even gotten to that point yet, because whether or not Mr. Lloyd wanted to surrender himself to authorities after committing the Dixon murder and prior to the Clayton murder, I don't know what material fact does that go to in either the state's elements or either of the defenses that are being put on.
It goes to my client's state of mind.
The client's state of mind is not at issue.
It is an issue, Judge.
No, it isn't. Not in the evidence, it isn't.
The evidence, we are allowed to show information that is consistent through evidence with my client's insanity.
Absolutely. And what evidence has been introduced in this trial?
Well, Dr. Toomer is going to testify that this is a pressure that causes him to go into a higher ratio of his thought process already that the police want to kill him.
The defendant's state of mind must be at issue in the trial before this evidence can come in.
So you're essentially saying that he has to testify, or there has to be some evidence of his state of mind?
I'm telling you that the law says that the defendant's state of mind must be at issue before this witness's testimony would become relevant.
It is an issue.
How you achieve that is up to you. It's not my job to tell either side how to present their case. At this moment, the only thing the court has heard about the defendant's state of mind is argument from counsel. No witness and no evidence has been introduced, physical evidence has been introduced that puts the defendant's state of mind at issue.
Then I'd ask the court to authorize a continued subpoena on Detective Savelli, because I'm going to attempt to call him at some point, if that's the court's ruling.
Not a problem. We would bring Detective Savelli in here for a moment so I can instruct him. No, I just need him where I can see him so I can tell him what his instructions are. Detective, you don't need to come all the way up. You will not be testifying today. However, you are still under subpoena and you are subject to recall.
Yes, ma'am.
All right, thank you very much. You're free to go today. Thanks. All right, who's next? Stribby?
Good. It's our intent to call.
I can't hear you.
It's our intent to call Mr. Stribby to testify to his initial statement that he gave the police.
So you want to put him on to say, I was interviewed at the scene. I vaguely remember this. I was interviewed at the scene and I don't know who shot first?
Yes.
Okay. That it?
That's it.
Yeah, the defense, at the second statement he gives, he said the defendant shot first. So knowing that statement, they're calling him sole purpose of impeaching him on that second statement.
No, he just told me that the only reason he's calling him is to get him to say he doesn't know who shot first, period.
When you dovetail into the beginning of the first part of that statement where he says, the officer shot first. Oh, wait, no, I don't know who shot first.
That was the statement he gave on the day of the incident.
Yeah.
He can put that statement in. There's no legal basis for telling him he can't put that statement in. That first statement. He's not telling me he's going to put the second statement in.
He knows the testimony from Mr. Stribby is going, I'm assuming is going to be the defendant shot first, which is the statement I believe that he would give based on what I
Well, that's why we're doing a proffer.
Yes.
So let's get him up here.
Thank you.
I haven't.
Both parties need to pull up two cases. I think it's Kingery. I'm not sure of the pronunciation versus state. It's Kingery, 523 Southern 2nd, 1199 Florida 1st DCA, 1988. and Austin, Austin versus State, 461 Southern 2nd, 1380, Florida 1st DCA, 1984. We'll get to those in a minute. We'll just want you to go ahead and start pulling them up. Let's put him under oath, please.
All hands to the box. Face the clerk. Raise your right hand, please.
You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Have a seat, sir. You can take your mask off. All right, Mr. Linneman, you may inquire.
Yes, Judge. Would you tell me your name, sir?
Brian Stribby.
Can you lean forward and talk into that mic so we can all hear you?
Brian Stribby.
And how are you employed?
Yes, sir. Yes, sir.
No, how are you employed?
Through KW Masonry.
Okay. Do you recall an incident that occurred back on January 9, 2017, when there was a shooting of a police officer?
Yes, sir.
And you were on the scene at the time?
Yes, sir.
And you met with detectives afterwards?
Yes, sir.
And what did you tell those detectives in regards to what you saw about who shot first?
I don't remember.
You need to clarify.
Well, there's a 4-page statement. So when you talk to the detective.
What's the date of the statement?
1/9.
Okay.
On January 9, 2017, you spoke with a detective.
Yeah.
Okay. And do you recall what you said to the detective about who shot first?
No, I do not.
Would anything refresh your recollection?
Probably a statement.
Okay. My approach?
You may.
Showing you the statement I'm referencing. Obviously, on page 2. You want to look at that, it's underlined, but you can look at the whole statement. Just let me know when you're done.
Okay.
Did that refresh your memory?
Sure.
Okay, and what did you tell the police?
That I don't know who shot first.
Did you ever tell the police that you thought she shot first?
In this statement, it says, I am not sure who shot first. It might have been the police officer. It might have been the guy.
And that's what your memory of your statement is?
That's what it says right here. So,
You would testify at call about that statement on that particular day?
yeah.
Okay, nothing further, Judge.
Cross?
As you sit there today, do you know who shot first?
No, sir.
Thank you.
All right. Stay, do you still have an objection to this testimony?
No, Your Honor.
All right. This witness may testify. All right. Who's your next proffer?
No, actually, Judge, before we do that, I want to make a motion.
Okay. Hold on until, Mr. Stribby, if you'll step out, please. Thanks. You're still under subpoena. Don't leave.
Okay.
Your motion?
I don't have it at this time, Judge.
Okay, so do you have another proffer that we need to make while the jury's out?
Sure, if you like.
Yeah, I'd prefer not to send him back out again. Is this Dr. Toomer?
Yeah, can we come sidebar?
Sure. right, let's bring the jury back in, please. Welcome back. State recognized presence of the jury?
Yes, Your Honor.
Defense? Yes. All right. All right. Defense, you may call your next witness. I have no idea. Where? Oh, no.
Call Brian Striby.
All right. Brian Stribby, please. Yes, ma'am. Hearing who? Me? Yes. I have all the mics on. Is anybody else having problems hearing me? You can't hear me either? Okay. Can you hear me now? Yes. I feel like a Verizon commercial. All right, thanks.
The sound square are affirmed. The testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am. It's 4 p.m.
Just have a seat, sir, and remove your mask, please. May I inquire?
Yeah. If I can have a moment, Judge.
Yes.
This is it. Would you tell me your name, sir?
Brian Stribby.
And how are you employed?
Through the construction industry, KW Masonry.
Did there come an occasion that you were at the Walmart parking lot on January 9, 2017?
Yes,
during
sir.
A shootout? And you spoke to the police that day?
Yes, sir.
Do you remember what you told them?
After reading my statement, yeah.
Okay. May I report? Approach to it?
You may.
Underline.
Okay, yeah.
Does that refresh your memory?
Yeah.
What did you say?
He says I don't know who shot first. So it could have been him, could have been the guy.
Can you lean into that mic,
Could have
please?
been the guy, could have been the police officer.
Did you ever say the police shot first?
No.
I want to show your statement again, see if that refreshes your memory. It'll be the second sentence.
Because I think the police officer shot first. I'm not sure who shot first.
Okay, read the rest of the sentence.
It might have been the police officer. It might have been the guy.
All right.
So.
Those are all the questions I have, Judge.
Cross.
Good afternoon, Mr. Stribby.
Good afternoon.
Mr. Lemon asked you if you were in the parking lot at the time this incident occurred, right?
Yes, sir.
Can I approach the witness?
You may.
Showing you the marked as State's Exhibit BR. You recognize what parking lot that shows?
Yes.
And when you were there in the parking lot, you were actually working, right?
Yes, sir.
Your job at the time was to clean the parking lot up?
Yes, sir.
Can you see on this diagram whereabout you would have been when you first heard gunshots?
Right by this white car.
Okay, I'm going to give you a red pen. If you could circle the general location where you would have been. And can you put inside that circle your initials, BS? Okay, thank you. And the statement that Mr. Lenneman just showed you was a statement you gave to the police the morning this all happened, right?
Yes, sir.
And I think you gave the statement at 7:39 in the morning?
Yes, sir.
About 15, 20 minutes after all this happened?
Probably.
The next day, did the police come and talk to you again?
I believe so.
And they did a longer, more detailed interview, correct?
I believe so.
Do you remember on that day, speaking of the bottom of page 6, do you remember at that time telling the detectives when asked, and who did you see fire the first shot, your response was a suspect?
No, I do not.
Okay. We should go ahead and show it to you. Might refresh your memory.
Okay.
Does that refresh your memory about what you told the detectives the second day?
Sure, yeah.
Okay.
I mean,
did you tell the detectives the second day the suspect shot first?
Obviously I did.
Okay. Thank you, sir. No other questions, Your Honor.
Redirect.
Do you remember what the name of the person who came to see you was the second
sir.
day?
No, sir.
Do you remember having an off-the-record conversation with the detective?
Do I remember what?
Having off-the-record conversation with the detective before you gave your second statement?
Not really, no. Except this is going to be recorded and stuff of that nature.
Did you have criminal charges pending at the time?
Yes, sir.
And as a matter of fact, you went on Facebook and told people that the police were going to help you. Isn't that right?
No, it was more like me talking shit, just saying.
Sir, watch your language.
Me talking crap, saying, you know, they want my testimony, they're going to have to drop my charge.
So that's what you said on your Facebook, you said?
Yeah.
Didn't you say that the cops were going to help you out?
Not to my recollection.
Let me show your
We're talking about Facebook 4 years ago.
all right, let me show you your statement that you gave in a prior hearing. It's the proper testimony. And I'm referencing to my cross-examination, and I circled what I think is relevant. Take a look at that.
Okay.
Did you tell the police? Did you tell people on Facebook that the police were going to help you out?
Yeah.
Because you thought they were going to help you out after you changed your story.
After I changed my story.
I didn't hear you.
I said after I changed my story, just a little chuckle.
And what you said, as you just mentioned right there, that if you were going to help them out, they would have to help you out, right?
That's what I was wanting, sure.
Yeah.
Did it happen? No.
So even though you thought it was going to happen, it didn't happen, you say?
No.
But you thought it was going to happen?
I thought it might have. Thought, you know, sure, maybe. But no, it didn't.
Okay.
I did time on that charge.
And you didn't think that after your first statement. You thought that after your second statement, right?
I don't remember when I thought that.
Okay. I have nothing further.
May this witness be excused?
Yes, Judge.
State? Yes, Your Honor. All right, thank you, Mr. Savelli. You're free to go. Call your, or Mr. Stribby, sorry. Call your next witness. Yes, sir.
Tanya Lloyd?
I'm sorry, who?
Tanya Lloyd.
Oh.
Go ahead and step up. Please, clerk, raise your right hand.
Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth to help you God?
Yes. May I inquire?
Would you tell me your name, ma'am?
Tanya Lloyd,
And where do you live?
here in Orlando.
Okay. Do you know Markeith?
Yes,
How do you know Markeith?
it's my eldest brother.
Okay. I want to talk about an incident that happened in 2014 at, I guess, the church you were going.
Yes.
Do you remember that?
Mm-hmm.
Do you refer to that incident as something specific?
Yes, that was the day that he stressed that he wanted me to get a life insurance policy on him.
Okay. And what was the reason he told you he wanted a life insurance policy?
Well, this particular day, it was not one of the ordinary. He actually showed up and he wasn't himself. And he actually was what I call having like a psychotic episode, whereby he was like foaming at the mouth, his eyes were glassy, and he was saying that the police were going to kill him. So I was asking him, I was trying to calm him down and asking him like what happened, and he was saying that he repeated what, we've heard him say on a number of occasions, that they've traded in their nooses for guns and badges, and they're gonna kill me, and you better get the life insurance policy if you guys wanna bury me properly. So it made such an impression on me that I did just that.
Okay. Let me show you what's been marked as defendants are for identification purposes. What is that, Annie?
It's a copy of the life insurance policy that I have on him.
Okay. And is it a fair and accurate representation of that life insurance policy?
It is.
Okay. And when did you take that out in relation to this meeting you had with him?
Well, because I had never seen him like that before, and I was actually afraid that something would happen.
Responsive.
Sustained.
When did you take that out, ma'am?
The issue date is December of 2014.
Move into evidence.
Any objection?
If I could see it first.
Sure. You'll show that to the state, please. Any objection?
No, Your Honor.
All right, this will be received without objection as defense exhibit number 16. May.
Thank you. Ms. Lloyd, did you ever have a conversation with the insurance agency?
I did.
And what was that about?
Objection, call for hearing.
Sustained.
Is one of the concerns you had about insurance is whether it would cover him if he were killed by cops?
Yes, it was.
Did you ever have a conversation with Markeith after he got better?
I did.
And what did he tell you in that conversation?
Objection, calls for hearing.
Sustained.
It's non-hearsay, Judge.
Let me see the attorneys at the bench. You may proceed. Oh, sorry. Ready? Okay.
And when you had a conversation with Markeith later, he told you he would be killed by the police?
Yes, he did.
Those are all my questions, Judge.
Cross.
Thank you, Your Honor. Good afternoon, ma'am.
Hello.
So you are Mr. Lloyd's biological sister, is that right?
Yes.
I assume you're aware that he's been charged with the first-degree murder of Lieutenant Debra Clayton? You're aware of that?
Yes, I've been present all week.
Okay, I wasn't sure, so I wanted to make sure. So you're also aware that he's claiming that he was insane at the time of the offense, right?
Yes.
Because you heard Mr. Lenneman's opening statement.
Yes.
Objection, Judge. The doctor is the one who makes that decision.
Overruled, Mr. Lenneman. Go ahead.
So you said that, was it Did you give a time frame for when he made this statement to you about being foaming at the mouth, and you said he was psychotic? Did you say when that was?
It was right before I actually took out the insurance policy.
Okay, and so that would have been in 2014, is that right?
Yes.
Okay, so what is it you do for a living?
I work in human resources.
Okay, you don't have a degree in psychiatry or anything, do you?
Aside from some basic college courses, no, I don't.
I asked you that because you said Mr. Lloyd was acting psychotic, but you don't have any special training in that area.
No, outside of some college courses, no, I do not.
Yes, ma'am. I believe you also said that he was foaming at the mouth?
Yes, he was.
Were you concerned about him that day?
Very much so.
Very much so. Did you think, well, you said he was having a psychotic episode. Did you think his physical presence, his life was in danger? Was it to that extent?
I mean, I guess so, because he just wasn't well. So anytime someone's not well, then there's a possibility of something happened to him.
Right. And you said you were very concerned.
Yes.
So when did you call the police or the hospital?
I did not.
You didn't call the police?
I did not.
Or the hospital?
No, that would have escalated if he feared them.
Well, you didn't say you had any fear of police or, of hospitals, right?
Not to my knowledge.
Right. So you didn't take him to a clinic or anything?
No.
You didn't take him to see any psychiatric treatment, did you?
No, I didn't.
Right. Even though your testimony here today is that you were so concerned because you thought his life was in danger.
I was concerned for his well-being, absolutely.
All right. And I'm not being funny when I ask this, okay? How well do you know your brother?
I think I know him well.
Right. Prior to his incarceration on this case, did you speak with him often?
I guess I would. It depends on what you would define as often. So
you tell me how often you spoke to him. Once a week, once every day, once a month? Can you describe that for us, please?
It could have been maybe once every 2 weeks.
All right. What kind of things would you talk about with your brother when you discussed?
Objection, relevance.
Overruled. When you had a conversation with him every couple weeks, what would you talk about?
Various things. We're siblings, so you talk about the weather, you can talk about anything.
Did he open up personal details of his life to you?
No, not that I can recall. And I guess that would go back to what you would define as personal.
Can you tell me anything that you would consider personal that you discussed with your brother, Markeith Loyd?
I mean, outside of normal day-to-day things, like I wouldn't probe into, anything pertaining to him specifically. But I can't tell you what we talked about. I mean, we're talking some time ago. So.
Well, the reason I asked him is because you're very specific about remembering his statements about being scared of police, right?
Yeah, when events are somewhat traumatic to you, you tend to remember them.
So you said events plural. Was there another event other than the one you just described to us?
Just speaking of this specific event.
Okay. Yes, ma'am, but you also told defense counsel that there were other times when Mr. Lloyd would tell you about his fear of police, right?
Yes, he did.
Okay, those weren't traumatic events, correct?
No, I mean, he would speak about that in casual conversation.
Okay. So is there any reason you remember those conversations but not anything else that he discussed with you?
I don't understand the question.
Right. I asked you if you could tell me some of the things you talked about with your brother, and you couldn't provide any specific information.
Objection. This is improper impeachment, Judge.
Overruled. That means you can answer. Go ahead, ma'am.
Because, I mean, you didn't ask me that specifically. We talked about a plethora of things. I mean, I didn't know at the time what to identify.
Okay. Identify some things, please.
Well, you just did.
What's that?
You just did. Like, we talked about, he mentioned in casual conversation about the police and how they were going to kill him. He mentioned the lynchings.
No. Anything other than what you've already told us. Do you remember speaking to him? Anything about
Objection.
Overruled. Do you remember talking about anything else with your brother when you've come here to testify about here today?
I mean, we talked about the weather. We talked about many different things.
The weather, that's one thing. What else?
We talked about my kids, how they're doing in school. We talked about his kids. We talked about many things.
Do you feel like you knew your brother well?
I know
based
my
on these
brother.
conversations?
I know my brother as best as I can.
Now, you've described his statements regarding fear of police, right?
Mm-hmm.
Is that a yes?
Yes.
Okay.
Sorry.
Did he ever say anything else about law enforcement?
Not aside from what I've just mentioned.
Okay, so he never shared his feelings with about law enforcement with you, other than, according to your testimony, that he was scared of them. Is that right?
Right, and how, what I mentioned earlier about how they traded in their nooses for guns and badges. They're
You've been
killing
very
our
clear
people.
about that a couple times now. I said she's been very clear about that a couple times now. So he never told you about any negative feelings he had about law enforcement. Is that what you're saying?
Not outside of what I just mentioned.
All right. Did he ever describe wanting to harm law enforcement officers?
No.
Did you ever hear him say that he wished ill will on them at all?
No.
That he wanted them to die?
No,
That he wanted to kill law enforcement officers? Did he ever say anything like that to you?
Not to me, no.
Are you aware of him saying that to anybody else?
I'm not, no.
Right. Even though you believe you know your brother pretty well, right?
Mm-hmm.
Is that a yes?
That is a yes.
Were you Facebook friends with your brother?
No, not. I wasn't for a while. I am now.
Okay. Do you remember when you became Facebook friends with him?
No, I don't.
So, based upon your testimony, I take it would be a surprise to you if your brother espoused a desire to hurt law enforcement officers. Am I right about that?
It would be.
Right. Because that wouldn't be the person that you know, right?
That wouldn't be anything that he's ever expressed to me.
You have permission to publish.
Judge, I have a
Exhibit
continuing
53?
objection to this.
Yes. Okay.
I'm sorry, Judge. May I publish?
You may. And, can
Ms.
you,
Lloyd?
for the record, which exhibit are you publishing?
53.
Thank you.
Ms. Lloyd, there's a screen in front of you, okay? I'm going to put up some of your brother's Facebook posts that are in evidence that states Exhibit 53. First one's dated December 9th of 2014. Could you read that statement, please? No, to yourself. You don't need to read it out loud.
Oh, okay.
It's on the screen. The jurors can see it. When you're done reading it, let me know, please.
Okay.
Does it surprise you that your brother would talk about death to crackers, referencing law enforcement officers?
I guess, yes.
Okay. I'm going to go up now and put the next post a little further down. It's December 15th of 2014 at 15:33 and 24 seconds. Read that one to yourself, please. I take it that statement is out of character for your brother as well. Is that right?
I mean, I'm reading it. It's posted.
Okay. Do you watch local news, or excuse me, do you watch national news?
Rarely.
Do you remember back in 2016, in the summer of 2016, that there were some police officers shot and killed in Dallas, Texas? Do you remember that?
You would have to give me more information.
Okay. I'm going to now publish page 475 of State's Exhibit 53. take a look at that article headline and see if you remember it.
No, I'm not familiar with that.
But you do recognize that it's discussing the fact that officers were shot, 10 of them, and 3 of them were died, right?
Yes.
Right. And now I'm going to pan out so you can see your brother's post following his posting that article. Do you see anything in that post that indicates your brother is scared of law enforcement?
I mean, I can't speak to that.
You can't tell me whether there's anything in there that indicates he's scared of law enforcement?
I can't say that. I could.
Bless you. I'm now going to publish posts that follow on July 8th of 2016, starting at 12/18/54. When you finish reading the entirety of the post, ma'am, just look up at me and then I'll know you're done.
Okay. Okay.
Now, those were posted in July of 2016. Do you see that on there at the very top?
Yes, I see the date.
Which would have been less than 6 months before he murdered Lieutenant Clayton, correct?
I get, if you say so. I don't even know the date this happened, so I don't know.
Okay. And in that post, he said the only good cop is a dead cop, right?
He's saying many things. That is one.
That's one of them. Would you agree that in this post he's expressing anger towards law enforcement?
That would just be an assumption from me that I care not to.
Well, you were assuming he was scared of law enforcement earlier, right?
Objection.
No.
Objection.
Overruled. Simple question. Are these words of anger?
I can't speak to his state of mind when typing this.
You don't know if saying that people should die is a word of anger?
I cannot
Objection.
speak. Overruled. I cannot speak to his state of mind when they're posting this.
So does it remain your testimony here today that your brother was scared of law enforcement?
My testimony is that he had a fear that he would be killed by the police.
Despite what you see here?
Yes.
A sister's love, right? I don't have any other questions, Judge.
Redirect.
Were you aware, Ms. Lloyd, that there are actually 30,000 pages of Facebook postings that are directly related to your brother?
No, I didn't know that.
Okay. He was an active Facebooker, isn't that right?
Oh, yes.
And were you aware that that your brother tracked the killing of black men around the country?
I know that he paid close attention to those things.
Okay. And that Tamir Rice was killed in November 2014.
Sustained. Rephrase your question, please.
Did you know that there were two black men killed that led up to this? Did you reference this shooting?
Yeah, I'm familiar with that.
Okay. They were Alton Sterling, Orlando Castillo.
I'm familiar with those names and what happened to them.
Now, during one of the a couple of Facebook postings, they were clearly close in time to this incident that you were involved in with your brother at the church.
Okay.
One is dated.
What are you looking at? This is the exhibit.
One is dated 12/9 of 2014.
Okay.
One is dated 12/15 of 2014.
Okay.
When was that insurance policy bought?
In December, I believe it was December 17th of 2014.
Wow, how coincidental that a rant and raving Mr. Lloyd is angry because of what he believes are injustices.
I don't doubt that.
Is that a question, Mr. Lenneman? Mr. Lenneman?
Yeah.
Ask a question.
I understand, Judge. Was your brother constantly talking about the impact of police and white folks on black Americans?
Yes, he did.
Was it in a way that it would be considered normal or something abnormal?
Coming from him, it was normal.
Okay. And was he fixated on it?
Very much so.
Now, he didn't start Facebook posting until he got out of federal prison.
That's correct.
And did he get out of federal prison in July of 2014?
I don't remember the exact timing, but
Okay. You know how many years he served in prison?
I believe it's about 17, I believe.
And was that for drugs?
Yes.
I have no further questions, Judge.
May this witness be excused.
Yes.
State.
I'm thinking about it, Judge. Could I have a moment, please?
You can.
Thank you very much.
Sure.
No, no, thank you, Your Honor.
No, she may
No
not be.
questions.
Oh.
I'm
No,
sorry,
my
what?
question was, may she be excused?
Oh, I'm sorry. Yes, she is excused. I apologize.
Thank you, ma'am. You can step down. You're free to go. Call your next witness.
Yeah, we would call Barry Jacobs.
Barry Jacobs.
Barry Jacobs.
Please, the clerk, raise your right hand.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, and nothing but God?
Yes.
Have a seat, sir. You may inquire.
Can you tell me your name, sir?
Barry Jacobs.
Okay. And how old are you?
39.
And do you know Markeith Loyd?
Yes.
And how do you know him?
That's my brother, older brother. Oldest, actually, I'm sorry.
What's the age difference between you and him?
7.
7 years? Okay, back in December 2014, do you remember an incident that occurred at your church?
My sister told me about it. I don't go to the church.
Okay. And shortly after you finding out about it, did you have contact with your brother?
Yes.
And describe what you observed and what he was saying.
It was a phone call. He was irate, and he was saying they were gonna kill him. They trying to kill him, and he'll be back.
What do you mean he'll be back?
Oh, he'll be back like Jesus. He said, "I'll be back like Jesus, though."
Okay. Did he say anything about his phone?
Yes. Said they was tapping his phone. Say they had his phone tapped and other stuff. Well, that's kind of how I remember.
Did there come an occasion sometime after December 13th, 2016 that you had a conversation or you were present for a conversation between Markeith and Kensha?
Yes.
And what did Markeith say?
Objection, calls for hearsay.
Sustained.
Did he indicate to you what he was concerned about?
Objection, calls for hearsay.
Sustained.
Did you have a conversation with anybody about going to the press?
Yes.
Tell me about that.
Objection, calls for hearsay.
Sustained.
Tell me not what you said to them, but what you plan to do.
Talked about who was gonna go out of me and my niece.
Well, okay.
Objection, relevance, and calls for hearsay.
And
Sustained as to hearsay.
what's your niece's name?
Kensha.
Okay. And do you know if she went to the press?
Yes.
Now, did there come a time when your brother had been accused of several murders, the Clayton and Dixon murders, and was on the run?
Yes.
Okay. Did you talk about how you could help him out?
Objection, calls for hearsay.
Sustained.
What were your thoughts about that and what you can do?
I was trying to get up with my mother to see if we could still get him a lawyer at that time.
Can I have a moment, Judge?
You can.
Those are all the questions I have, Judge.
Cross.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
So,
Mask.
thank you, Your Honor.
No problem.
So based upon this conversation back in 2014, was it your belief that your brother was fearful of law enforcement?
Yes.
Right. Did he ever say anything negative to you about law enforcement?
No.
Did he ever indicate to you any desire to hurt law enforcement?
No.
Any desire to kill law enforcement officers?
No.
So if you were to hear that he said things of that nature, that would be a surprise to you, right?
What do you mean?
Well, he never said it. Well, do you think your brother wants to hurt law enforcement officers?
No. Still don't. Nope.
Still no.
Mm-mm.
Right. So you would be surprised if he talked about killing police officers prior to killing Lieutenant Clayton.
That's why I say, what are you referring to?
I'm referring to whether or not you're aware
Like
that
if you mean like verbally, or you mean like the statements on Facebook?
Oh, you're aware of the Facebook statements?
Yeah, me and him are friends on Facebook.
Okay. When did you become aware of the Facebook statements?
My family.
And no, that was who? I said when. When did you become aware? I took your deposition yesterday, remember?
Mm-hmm.
Is that a yes?
Yes.
Were you aware of the Facebook statements yesterday?
Yes.
You were. Do you remember me asking you if you were aware of any statements?
Objection, proper.
Overruled.
Judge, he's
Mr. Lenneman. You may proceed, Mr. Williams.
So is it your testimony here that you were aware of the statements on Facebook yesterday?
They were made aware by my family.
I need you to answer my question.
Were
you aware of the statements on Facebook yesterday when you gave a deposition?
So you want the long one or the short one?
Well, you could start by saying yes or no and then explaining.
Okay, so was I aware? No. My family made me aware of the statements.
Right, that's my point, sir. So after I deposed you, your family member told you the things you didn't previously know, right?
No.
No? Explain that. Just explain that to me, please.
Me and him are friends on Facebook.
Go ahead.
But I don't read the Facebook statements.
Right.
So when it comes to like saying like when it happened, they say, oh, you heard about this? No, because I don't read them.
I see. So is it your testimony that you were aware that he wanted to kill law enforcement officers, you just didn't read the statements?
No, once again, if I didn't read them, I don't know.
Okay. I guess regardless, you're aware now that he threatened to kill law enforcement officers on Facebook.
Once again, on the context of the statement, if I read them when it happened, I would have a better context.
Okay. I can show them to you if you want.
Sure.
You want to look at them?
Yeah.
Okay. So you've never seen them before? May I approach you?
You may.
It's Exhibit 53, and I'll just flip to page 475. Just read that page, or look at the picture and the caption, and then read the following page to yourself. Just read it to yourself. And then when you're done, let me know, okay?
This was around 16. Mm-hmm.
Had a chance to read them?
Yeah, some of them. I read a little slow.
No, it's okay. Take your time.
Oh, this was, okay.
Right. It was after the Dallas shooting?
Yeah.
Right. Yes, sir.
So this was it's an officer shot demonstration in Dallas. So who did the shooting in Dallas? Because I don't watch the news like that at all.
I'm not sure of the exact name, but you would agree that the article references the fact that 3 law enforcement officers were dead, right?
Yes.
And your brother is talking about killing law enforcement officers.
No, it sounds more like a statement of what they did and him saying, we never have justice.
You see the one where it says only good cop is a dead cop? You see that down there?
No, I don't see that one. Which page is that on? You can.
Page right after the article with the picture.
Say we lost millions. I have no sense. We dying at the hands of these crackers. We've been dying in their hands for hundreds of years.
Keep going.
All right. Y'all crackers being evil. Yeah. Oh, 3K. Oh, okay.
Okay. So do you see the statement I'm referring
Yes,
to?
yes.
Right, and it's your position, is it my understanding that it's your testimony that that doesn't mean he wanted to kill law enforcement officers?
No.
Okay. All right. Thank you. Thank you for looking at that for me. I appreciate it.
You're welcome.
Let's talk about a slightly different incident and topic. You had an opportunity to observe your brother around some law enforcement officers, right?
Yes.
Right. And just for context, it's your testimony that he was scared of law enforcement, correct?
Yes.
Right. Tell the members of the jury about the time that you were with your brother when law enforcement had contact with you and him and some others.
I was driving my car, trying to take him back to the work release center.
Sir, can you lean in closer to that microphone to the camera?
So I was driving to my car, trying to take him back to the work release center that he was in, and the police pulled us over for making a left turn. For
Yes, sir.
me making a left turn.
And he was in the car, right?
He was in the car.
Right? And how many officers ended up showing up that day?
It was like 2 cars.
3 in 2 cars. And your brother was sitting next to you in the front seat, right?
Mm-hmm.
Is that a yes?
Yes.
Okay. You got out of the car, right?
Yes.
It's cross-examination.
Yeah, it's overruled.
Did you see your brother get upset at all during the traffic stop before you got out of the car?
He slumped back in the seat. I asked him to get my registration and my insurance out of the glove box.
Right. So
before the police
in other
officer
words,
came up. I say before the police officer came up, I asked him to grab my license, my registration, and my insurance card out of the glove box.
And did he do that?
Yes.
Right. Did he have any type of foaming at the mouth incident?
No.
No. All right. And there were law enforcement present, right?
Yes.
Okay. He gave you the registration and you got out, correct?
Mm-hmm.
Is that a yes?
I say yes.
So prior to you getting out, everything seemed okay with him, right?
Like I say, he slumped back in the seat. He let the seat all the way back.
Okay. So he was relaxed.
Yes.
Okay. And then you dealt with law enforcement, right?
Mm-hmm.
Is that a yes?
Yes.
It's okay. Everybody does it. And in fact, they didn't give you a ticket, did they?
No.
No. And then you got back in the car, right?
Yes.
And you drove off.
Yes.
And Mr. Lloyd was fine the entire time.
No, you asked me that yesterday, and I told you the same thing. Once I got back in the car, the ride that I had, I didn't even have time to look over and ask him, was he okay?
The entire rest of the ride, you never looked over and asked him if he was okay?
No, because I was speeding, trying to get back to work.
Well, you
I
just
had
got pulled over and you were speeding.
But I told you to say I wasn't speeding when I got pulled over.
Oh, okay.
I told you yesterday, same thing. I had a 30-minute ride to get from Sand Lake and OBT to Edgewater and OBT and get back over there.
But you would agree then that you never saw your brother get upset during that entire interaction?
When I asked him for the only time I seen him and I paid attention when I said, hey, grab me my insurance and my registration out of the glove box.
That's all I have, Judge. Thank you. Thank you, Mr. Judge.
Redirect.
Sir, you were saying that you were a Facebook person on Markeith's, but you don't really follow it. Can you tell me about that?
I post jokes on Facebook. That's all I use it for. I don't go on there and read everybody's comments, read statements. I don't let it control my life like that. I just post a joke or post a funny meme and keep it moving. I go to work.
Okay. And when your brother got out of prison in July of 2014, did you get to spend, obviously, more time with him than you got to see him over the years while he was in prison?
Just a little bit more, but like I say, I drove trucks. I went from driving trucks over the road to a local gig, but I was still gone.
Okay.
So my hours wasn't.
Now, you were saying that you don't believe that what he's saying is he wants to kill a cop.
No.
Tell us why. Tell the jury why.
Because my brother was never on that, to me, he was never on that type of, I say time. He was never like really the type of person that'll tell you, like, we'll talk about what they doing to us, but to be like, I'm gonna go do this to them, we would never, that was never in the same sentence.
Now, between July 2014 and November, December 2016, how much interaction did you have with your brother?
Say the time again?
July 2014, November, December of 2016.
I think I stayed with him the last 4 months.
Okay. And where did you stay?
Off of 18th Street. I don't know the address exactly.
And was it his apartment or house?
Yes, his house.
So he let you stay there?
Yes.
Okay. Now, during that period of time, do you remember your brother being more verbal about what he thought was mistreatment, racism, and the way that blacks have been treated historically?
Yes.
Okay. More than an average person would?
Yes, I'd say.
A lot more?
Yeah, that's kind of like me and him talk about the same thing. Like, I talk about it too, but I look at it kind of differently.
Okay. You don't have his mind?
No, like, I understand they harass us, we get harassed, we get pulled over a lot, I understand that. So then my thought process is how to maneuver through the system. I call it the system. So, okay, I know they're gonna arrest us, so pull us over. So how can I do anything to avoid getting pulled over?
Okay.
What can I do? Speeding, not making sure, like, I got cars, make sure my windows ain't tinted, super tinted, stuff like that.
Sustained.
And without saying what you guys talked about, was there conversations between you and your family through that period and from January 2014 to November and December of 2016 about Markeith's mental health?
Yes.
Nothing further, Judge.
All right, may this witness be excused. Defense?
Yes. No.
All right, sir. You're excused for now, but you're still subject to being recalled, so you're still under subpoena. So you can step down.
Okay.
All right, thank you. All right, ladies and gentlemen, this is a good time to take a quick break. I'll be right back with you in a minute. Thank you.
Okay.
Mr. Lineman, do you have any further witnesses before any proffers?
I'm sorry?
You need to stand up when addressing the court, Mr. Lineman. I'm tired of telling you this. Do you have any further witnesses before the proffer of Dr. Toomer?
No.
All right. Are you intending on proffering Dr. Toomer?
No, but I plan on making an argument that the state has opened the door to state of mind by introducing those Facebook pages, and now that we should be able to bring in all the evidence of state of mind through Dr. Toomer.
I don't know what the evidence of state of mind through Dr. Toomer is. I have no idea what Dr. Toomer is going to say. You all keep forgetting. I don't have his depo. I haven't listened to his testimony. He didn't testify at the last trial, did he?
No.
All right, State, you have a motion on Dr. Toomer, is that correct? On Dr. Toomer's testimony?
Yes, Your Honor.
All right. So we need to take care of this motion. It's 410 is the reason I'm asking you this, and we need to do the shackle hearing.
Yes, Your Honor. Well, when Your Honor says a motion on Dr. Toomer, the only motion that I have on Dr. Toomer that I can recall is the hearsay motion.
Correct.
Okay, just making sure.
Which is the one that I said I needed a proffer of Dr. Toomer's testimony before, so that we don't get into all of this in front of the jury. And you're saying you think they've opened the door to what?
My client's state of mind by putting out there killing cops and all of that, which is related to his mental illness, Judge.
State, what's your response?
Well, we admitted the Facebook post in our case in chief on the issue of motive and premeditation.
Correct.
The defendant's state of mind is always relevant if there's evidence of insanity. It has never been our position that Dr. Toomer cannot testify about evidence or testimony or statements of Mr. Lloyd that go to state of mind at the time of the offense. But nothing that we have introduced or cross-examined the witnesses on would open up Mr. Lloyd's statements about how he feels about racism or anything else.
All right, you need to be as specific as possible. You need to be as specific as possible with me. Exactly what is it that you are saying Dr. Toomer cannot testify to at this point?
Statements, I will do my best, Your Honor. Statements about what Mr. Lloyd experienced as a child, if they come exclusively from Mr. Lloyd.
If they're coming from Mr. Lloyd?
Yes. What he experienced as a child.
Oh, you mean if the statement to Dr. Toomer came from Mr. Lloyd? Okay.
I'm referring to things that Dr. Toomer would say that I believe are not admissible. Anything that happened when Mr. Lloyd was a child in the way of racism or the way he was brought up. By way of example, Mr. Lloyd told Dr. Toomer that the KKK marched past his house, for example. Anything about him living in poverty or stealing food for his family. Anything of that nature, and frankly, anything that is not related to his actions, Mr. Lloyd's actions on the morning of January 9th, 2017. I just gave the court some specifics that I know Dr. Toomer would relay.
All right, as to Mr. Lloyd's feelings about the police, why have you not opened the door by questioning his relatives about it?
I think his feelings about the police are relevant, but not Dr. Toomer expanding on why Mr. Lloyd feels the way he does about the police.
So you'll concede that Dr. Toomer can, with the evidence that's been introduced so far, just trying to make sure I know what the parties are arguing about.
I understand, Your Honor.
That, number one, Dr. Toomer can testify to anything Mr. Lloyd told him about what happened the day of the incident.
Agree. Yes, Your Honor.
That Lieutenant Clayton was shot.
Yes, Your Honor.
All right. And Dr. Toomer can testify, if I understand you correctly, that Mr. Lloyd has a fear of the police and has a hatred of the police, whichever one it was that Mr. Lloyd told him, but not how he got to that point?
Yes, Your Honor, because what Dr. Toomer will do is say, this is all based on the totality, and he told me X, Y, Z about his background in life, and because of that, I reached this conclusion. I agree that if Mr. Lloyd told him he was specifically fearful of the police, that is relevant, and we will not object to that testimony.
Okay.
But anything beyond that is the state's position is he is acting as a conduit for inadmissible hearsay.
All right, response, Mr. Lennon.
Well, first of all, Judge, I attached the deposition to my response. And it's crystal clear, Judge, that the conversations he has with Mr. Lloyd and family members and the records and all of this is a dynamic part of his making a decision on prong one, which is whether my client is mentally ill. And he does make a decision on prong one based on the totality of circumstances, as Mr. Williams snidely remarks. But here's another issue.
Stop
Judge.
making personal comments. Go ahead.
Here's another issue. Their doctors don't find him mentally ill at all, Judge. And so the process my doctor uses to get there is super important because they have these two experts who are going to say there's nothing wrong with Mr. Lloyd other than he's antisocial or whatever. And so it's important for a doctor, if you go to a doctor and you have post-traumatic stress, the doctor's not going to say to you, okay, tell me about yesterday. He's going to look at your history, your life growing up, events that transpired, things that are signals to him that he is suffering from trauma, and the same way with mental illness. So all these things are important. They want to say they're self-serving and a conduit, Judge. They're not a conduit. These are things that happened to Mr. Lloyd to get him to where he's at today. And we intend to present 30 pages of Facebook documents that were provided to Dr. Toomer to review in the course of his evaluation.
I think the issue that is occurring, Mr. Linneman, is not whether things that the doctor was told can form part of his diagnosis and part of his reasoning for reaching that diagnosis. The issue that is occurring is timing. The doctor himself cannot be used to put in testimony and evidence that cannot be cross-examined by the state because it's hearsay. So it's really a timing problem, not the doctor can't ever testify to this. It's that you want to call him and put him on the stand, and having testified to all of these things, and I agree, he can testify to anything about what happened the day of the incident. He can testify to, because Mr. Lloyd's fear of the police, that's come in now, that's in. He can testify to, well, I don't know that he's going to testify to this, but to the Facebook postings about Mr. Lloyd's comments about police officers and all that was shown to the jury and is in evidence right now. All of that is already in evidence. The rest of it is not. And the rules are clear. The rules are clear that experts cannot be used to bring in evidence to avoid the defendant taking the stand and being cross-examined on this. So he can't get up and tell Mr. Lloyd's story for him. That is not allowed.
Mr. Lloyd is going to tell his own story, Judge.
And when he tells that story, then everything that the doctor based it on would become admissible. And it's not, the problem I'm having is the order in which you're telling me you want to do this.
Okay, here's the problem, Judge. The problem is that Dr. Toomer is not available Monday. So our initial plan, after discussing with you sidebar about the issue of him being used as a conduit, I spoke to Mr. Lloyd about that, and he said, let me testify now. He was talking about today.
Okay.
And then I said, well, you know, Saturday. But the problem with Saturday, Ms. O'Shea went out, and Dr. Toomer's not available on Monday.
How long do you expect Dr. Toomer to testify? Because we have court tomorrow.
No, I understand. But if he goes first, he was 4 hours last time, Judge.
So you're expecting Mr. Lloyd to be another 4 hours?
I'm not expecting that, Judge.
Okay, so how long are you expecting Mr. Lloyd? Because I can play with the time tomorrow.
A couple hours.
All right, so that puts us at about 11 o'clock, if you push your other expert that you told me about. And then Dr. Toomer can take the stand.
That's fine.
And how long is Dr. Toomer going to testify?
With all this stuff out, and assuming the court's going to allow it in, it's not going to be
As
detailed.
long as it's in evidence, it's in evidence, then he can testify. Yeah.
Right. So, not more than an hour and 15 minutes.
State, do you agree with that timeline? Because I need to prepare for tomorrow.
Candidly, that has not been my experience with the good doctor, but if they want to limit if they believe they can get his testimony out in an hour and 15 minutes, I'm not going to argue with that. And I think my cross of him will take an hour.
So 11, an hour from him, an hour from you, that's 1 o'clock. If I have to push it till 2 to finish Dr. Toomer, I'll push it till 2. We'll just make sure that we have a snack here for the jury so that they don't, and you all may want to bring protein bars so you keep and I'm not being facetious about that, so you keep your energy up, because we'll just go straight through that way.
Yes, Your Honor.
All right, so, Mr. Lloyd, I need to talk to you about you testifying.
Right. My client is voicing concern that because of the scheduling availability of Dr. Toomer, that he's going to be cut short in his testimony.
No, I'm not cutting him short.
Judge, we'll serve Dr. Toomer with a subpoena right now, and he can go nowhere if that's the real issue.
I'm not cutting Dr. Toomer short. I mean, I don't mind running over tomorrow.
He's already under subpoena, Judge.
That's fine. Then he's here, and I'm not intending on cutting him short. Well, you're telling me the latest we're going to finish with him is 2 o'clock. So there we
If
go.
we push him to 3, then we push him to 3.
It is what it is, Mr.
Okay.
Lloyd.
We're with you.
Mr. Lloyd, raise your right hand. I'm going to ask you to affirm. Do you affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? All right. Mr. Lloyd, as I explained to you yesterday, you are the only person who can decide whether or not you are going to testify. You're indicating that you want to testify. That's what your attorney is telling me. Do you want to testify in this case?
Yes, I was always going to testify.
All right. Do you understand that you have the absolute right to remain silent, and you do not have to testify if you do not want to?
Yes.
Has anyone pressured, forced you, or threatened you to get you to testify?
No.
Has anyone pressured, forced you, or threatened you to get you to not testify?
No.
All right. Have you had sufficient time to talk to your attorneys about the decision to testify in this case?
Yes.
And do you understand that, you may as well leave the mask down because I have several questions. Do you understand that you can change your mind up until the moment you start answering questions?
Yes.
All right. Do you also understand that when you become a witness, your prior record comes in the form of, they can ask you, how many times have you been convicted of a felony?
I know how that goes.
Okay. I have to get this on the record, Mr. Lloyd. Has the defendant been told, do you all have an agreement as to how many prior felony convictions he has?
Is that a felony? 8.
8?
Yes.
All right. Is there any dispute? If there is, I need to know, because Mr. Lloyd, the question's going to be asked at some point by somebody, do you have 8 prior felony convictions? If you say no and there's more than 8, they can introduce the judgment and sentence. You understand that?
Yes,
Otherwise, all they can do is ask you the number.
Yes. Well, he'll check the number, but it doesn't matter. That's just a tool they use to try to keep.
Okay, just focus on my questions, Mr. Lloyd. Talk to me.
Yes, ma'am.
And focus on my questions. Now, the other thing you need to be aware of is this, Mr. Lloyd. This court has ruled repeatedly that the loss of your eye and the manner in which you lost your eye is not admissible at this phase of the proceedings. Do you understand that?
Yes, I understand why you did it.
You are not allowed to testify to that. Do you understand that?
Yes.
And if you do, there may be sanctions. Do you understand that?
Yes.
All right. Is there any other things I ruled inadmissible that might come up other than the eye?
At this point, Your Honor, your ruling is that the details of Sade Dixon's murder are not admissible.
Unless he opens the door. Okay, that one, I ruled it because we couldn't figure out, I just didn't have any confidence in what it was that the defense was going to argue. So if he opens the door, he opens the door.
We
And the
understand,
state
Judge.
can rebut.
We understand, Your Honor.
Okay. All right. I'm done talking to Mr. Lloyd about his testimony. It's obvious to me he wants to testify, but again, if he changes his mind, that's fine. I'm going to go ahead and send the jury home for today, since we don't have any other witnesses we can call today. So let's bring them back in just so I can tell them they're going, or you know what, they don't really need me. Tell them that court is in recess as far as they're concerned until tomorrow morning at 9 a.m. and that I'll see them there. And would you tell juror 927 I'm working on the letter and I'll have it tomorrow morning. Okay, thanks. Thank you. So, shackle motion. This is an oral motion. Okay, so sheriff's office, get whoever you're going to get up here. All right.
Your Honor, can I speak?
Yes, sir.
We made a proffer verbally yesterday about what Mr. Lloyd would testify to, and we followed on the Dixon issue, and we filed a proffer this morning at 8:52.
Have you got your mic on? Have you got your mic on? You made a proffer yesterday? When?
Yeah, when we were sidebar, Judge, about what we were going to get into in our case in chief.
Oh.
Mr. Lloyd testified.
Okay, go ahead.
So anyway, this is the exact same thing that we proffered to the court yesterday, but
What is
Mr.
it?
Lloyd wants me to, can I approach?
Sure.
It's already been filed, but Mr. Lloyd wants me to reemphasize that that's,
You filed this in the court file?
yeah, it was filed. You can see the stamped copy.
Okay. State, you have a copy of this?
Yes, Your Honor, I was electronically served with it this morning. My review of it is that is almost exactly what was read to the court yesterday afternoon that
Yes.
Mr. Lloyd had written.
Okay.
Well, I can tell you right now that involving me in his testimony is not proper. I mean, this statement about the court knows this because the court was involved in the first trial. No.
Yeah, we don't plan on involving.
Okay, yeah, you need to leave me out of this. So again, normally evidence of other crimes is not admissible. If he wants to open the door, the only thing I'm telling everyone is the state gets to respond. So
We believe the door was already open.
I can't hear you when you're sitting down, Mr. Romer.
With their introduction of the bullet fragments over our objection, we believe that that door was opened.
I'm not stopping anybody. All right. So shackle motion. Let me know when the sheriff's department's ready. All right. It's my understanding that, Mr. Lenneman, you're requesting that we unshackle Mr. Lloyd for purposes of his testimony?
Yes.
Can you tell me Can you tell me exactly what it is, why it is that you need him to be unshackled?
Yes. Judge, I would use Defense Exhibit 10, which is a blow-up of the Walmart.
Okay.
And have him come down and testify as to where he ran exactly, what his plans were, that kind of thing, using that.
So you want him to point out where he was?
Yeah, point out.
You want him to just point out to the jury where he was?
Yeah, well, he's going to, I imagine it'll be, explain what happened, and he's going to give a narrative. Then I went this way, then I was going this way, I heard a shot, and I came back around, pulled my gun.
All right.
That's essentially what we want to use it for.
State.
I've not heard, well, what are you asking me to respond to? Just generally respond to the motion?
You can have a seat while we wait, Lieutenant. Go ahead.
It is hard for me to fathom a more dangerous situation than allowing Mr. Lloyd to run around the courtroom unshackled. We vehemently object, and there's nothing that was just described that can't be done with a laser pointer from the witness box.
All right. The Sheriff's Department has also indicated that they have some security concerns. So we have a witness here. As you all know, it's a shackle motion, so the state is responsible for asking questions. Mr. Lenneman, you can cross. Let's put this witness under oath, please.
The solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, you can take your mask off, Lieutenant.
Thank you.
You may inquire.
Could you tell me your name, please?
Jennifer Chancey.
Chancey?
Yes.
Spell your last name, please.
Chancey.
And where are you currently employed, Ms. Chancey?
Orange County Sheriff's Office.
How long have you been a member of the Orange County Sheriff's Office?
Approximately 20 years.
What is your current role at the Orange County Sheriff's Office?
I am a lieutenant in the court security section.
What are your duties as a lieutenant in the court security section?
I am the manager over many squads within the court security unit.
So we don't assume the court security would include this courthouse, the Orange County Courthouse, is that right?
It does include this courthouse, yes.
Have you become aware that defense counsel for defendant Markeith Loyd has requested that he be permitted to be present in the courtroom without shackles?
Yes, sir.
Did you do some research or have you information relevant to that particular request?
Yes, sir.
What research did you do? What types of facts, before you tell us what they are, what types of facts did you look for in trying to respond to that request?
His criminal history, his history of what types of arrests he had, his ability to follow instructions of law enforcement and corrections.
All right, so does the sheriff's office have an opinion as to whether or not Mr. Lloyd should be permitted to roam freely around the courtroom?
We do.
What is the sheriff's office opinion based upon the information that you've reviewed?
That he should not be freely roaming around the courtroom.
So you said you reviewed his history of arrests. Can you tell us about his history of arrests?
Yes, it's several pages long, includes many counts of battery on law enforcement officers, resisting arrest with and without violence, other violent type crimes against persons, batteries, and that sort of thing.
And specifically, what concern does that give the Orange County Sheriff's Office about Mr. Lloyd being present in the courtroom with other law enforcement officers without shackles?
Well,
what are you concerned would happen?
There is a serious concern that he is unpredictable and will potentially be very close to many people in the courtroom that we would not be able to readily control his movement.
Who are, and for record purposes, you're going to have to describe this, okay? Who specifically in the courtroom are you concerned about their safety if Mr. Lloyd is permitted to move freely about the courtroom without shackles?
Well, in this immediate area would be court personnel, jurors, yourself, and the other prosecutor present are in the immediate area.
Did you also review records of Mr. Lloyd from the Orange County Jail?
Yes.
Are there incidents documented with Mr. Lloyd that gave you more specific concerns about his ability to obey commands from law enforcement if he is unshackled?
Yes, there's been numerous incidents within the Orange County Jail where he does not follow instructions and has destroyed property within the jail.
Do you feel, would you be concerned about the safety of other participants in this proceeding, including the court, if Mr. Lloyd were to remain unshackled for any length of time in the courtroom?
Yes, sir.
Can I have a moment, Judge?
Currently serving a life sentence.
Right. Not so bad. We can argue that. Well, and are you aware of whether or not Mr. Lloyd is currently serving a prison sentence?
I am.
And what current prison sentence is he serving?
5 terms of life.
That's all, Judge. Thank you.
Shalana Cross.
Ma'am, how long have you been head of the security detail?
For what?
For this building?
Approximately 4 months.
Okay. Did you work on the security detail prior to that?
No, sir.
Okay. So you wouldn't be aware that at the last trial of Mr. Lloyd's, he was allowed to step down without shackles and present explanation of a demonstrative, right? You weren't aware of that?
Not personally, no.
Okay. And at that time, he was facing, obviously, the counts that were pending at that trial, which are the ones he's now convicted of. And obviously, this pending case that he was on arrested for.
Correct.
Okay. So what are the circumstances that you believe have changed in regards to what happened last time and what's going to happen this time?
Well, I'm not privy to what the argument was last time for allowing the freedom.
Okay, that's fair. All right, nothing further.
Redirect.
I do have one thing. It is beyond the scope of the cross.
So he gets recrossed, yeah.
That's, yes, sir.
Go ahead.
For record purposes, I'm holding up, I'm going to obtain defense exhibit number 10. May I approach the witness, Your Honor?
You may.
Ms. Chancey, I'm going to hand you a laser pointer.
Okay.
Okay. Press the green button. Okay.
Okay.
Could you point it at this screen and see if you can see?
Yes.
Can you see the pointer and areas specifically on the diagram?
Yes, sir.
Any problem seeing that?
No, sir.
That's all I have, Judge. Thank you.
No, you can recross on this.
Okay, thank you.
Area.
Ma'am, if he was wearing a stun cuff, do you think that would be sufficient?
That is not necessarily my... I don't know that that alone would be sufficient.
Okay. What is a stun cuff?
It is an electronic device which provides a shock of sorts to provide control of an inmate.
And what is it intended to do if it's used?
To gain compliance from the person.
Knock the person down?
I would say no, just provide a
This may be getting into security issues. That
yeah,
we're not allowed to discuss.
I can't really exactly tell you technically, I mean, but the purpose of it is to have them comply with our commands.
And is there someone in your department, either under your supervision or otherwise, that could come and explain it to the court in camera without the attorneys present or anyone else about how that works and what it does?
Well, I'm not sure anyone but the manufacturer would really know how to explain to you the workings of it.
For the record, Mr. Lunneman, I'm aware of how the stun cuff works in
Okay.
terms of compliance.
Okay, thank you, Judge. No further questions. Thank you, ma'am.
You're welcome.
Anything else? All right, thank you, Lieutenant. You can step down. Any other witnesses? Do you want them?
No, Your Honor. State has no additional witnesses.
Mr. Lunneman, do you have any witnesses you want to call on this?
No.
Argument, state.
Your Honor, only as to the stun cuff, because that's the thing that has not been addressed yet. It's pain compliance. It doesn't physically limit the individual wearing it at all. So if they can basically fight through the pain, they're unlimited in their movement. Mr. Lloyd has a violent history, and that is extensive. Because Your Honor tried the first case, you're aware of what the allegations that were proven in the first case were. Leaving aside, we just had a motion yesterday about Mr. Lloyd's conviction for instigating a mutiny that involved actions on a corrections officer, his prior conviction for battery on a law enforcement officer, which Your Honor has heard testimony, record testimony about in the other case. And perhaps most importantly, there is nothing based upon the demonstration here in court that he cannot point out on the demonstrative aid with the use of a laser pointer from the witness stand with shackles on his legs. We would ask the court to deny the motion to unshackle him for the safety of all participants of the proceeding.
State want to comment on the fact that he was unshackled at the last trial, and I gave him very specific instructions, and he did comply with those. Do you want to comment on that?
Right. Had Mr. Lloyd been found not guilty in the last trial, he would have potentially been released. He is now serving 5 life sentences, and I think the phrase has nothing to lose.
All right. Thank you, Mr. Williams. Mr. Lunneman, your argument?
First-degree murder charge on a law enforcement officer, which he was then and he is now. So, I mean, my concern, honestly, Judge, is you're having my client who's been institutionalized for most of his adult life point a pointer to an area which is extremely important for the jury to understand. And so if he's pointing and it's going like this and this and this, there's a difference between him being able to say, well, I came this way and then I went that way and so forth and so on.
Is there some reason you can't put it up here right next to him?
We may be able to do that, yeah. Yeah, I think we can try to catty corner it.
Now, he can just point from the witness stand.
Okay, good idea.
The big difference is he is under a sentence of imprisonment, and honestly, we've told the jury this repeatedly. I think they won't be shocked by the fact that he's not free to.
Okay, I think
so
that,
if you can
work it.
Is there some place we can put this, officers?
Like maybe here?
I have lieutenants, captains in the back. Is there some place we can put this that the sheriff's office is comfortable with, that Mr. Lloyd, without moving from that witness stand, can point at it?
It actually probably would be better than a pointer, something like a stick.
Oh, no. That was a good try, Mr. Lemon. That is not happening. Can we put it right there on that ledge? It's right there.
Okay.
Can you?
Let me see.
Yeah.
Or can I look?
Let's have the exhibit. I mean, I don't need to actually see him. I can apparently tune into several stations and watch him on TV. So.
Yeah, that works. Assuming.
We just have need somebody to hold it up.
Yeah.
Someone's going to have to hold that for him.
Right.
From the defense.
Ted will hold it up.
Deputies do not hold things
Correct.
for people. Okay.
If you want to go see if the stewards can
you have
see
any
it from there.
objections to this?
What's being proposed? No, we do not, Judge.
Okay. So that's what we're going to do. We're going to put it right up there next to him.
Yeah, you can see it. All right. Judge, just for the record.
Yes, sir.
None of the other witnesses did this, and the jurors will probably look at it as he's dangerous, and they are not letting him move.
Noted. Court's going to order him to remain shackled. We'll put the exhibit up there. I do find that the addition of he did do what I asked him to do last time, but the addition of the 5 life sentences is a factor that wasn't existing at the prior trial. So at this point, he can remain seated. We'll put the exhibit up there for him. Jury can see it. He can point to it. And as I said, the jury's been told he's been convicted of 5 life sentences. They can't possibly think he's not in custody. All right, anything else, folks? All right, we're in recess until 9 o'clock tomorrow morning. Thank you.